Hello, friends, and welcome to the National Constitution Center. It is so inspiring to see a full house for our annual Supreme Court review. I'm so excited to introduce the panelists to you in a moment and to say that this is the kickoff event for a series of celebrations of America's 250 that will really launch in the fall. On Constitution Day, September 17th, the NCC is going to launch a new civic toolkit and interactive Declaration of Independence. We've convened America's greatest historians to write about the big ideas of the Declaration and the Constitution. Danielle Allen on equality, Robbie George on liberty, the great Gordon Wood on government by consent. Akhil Amar is going to annotate the entire Declaration of Independence. And we're going to put it all online with discussion questions for reading groups across the country, teaching material for kids, and take this on the road for America's 250 and convene discussions of Americans in states across the Union about the principles of the Declaration and the Constitution that unite us. It's so exciting to launch with you, our great community of lifelong learners here in Philadelphia on Independence Mall. I know how many of you are eager to be part of this great mission for lifelong learning and deep reading and learning about the Constitution, and there'll be plenty of opportunities for you to convene groups and to volunteer and to take all this light across the country for America's 250. It's very meaningful to host our annual Supreme Court review here in June. For many years, as you know, the NCC has co-hosted a Supreme Court review with the Anti-Defamation League. They're no longer able to be our co-host, and it was so fortunate that the visionary dean of the Texas A&M Law School and I ran into each other in Texas a few months ago, and he proposed a new collaboration, which we're hoping to carry forward. As you'll hear in a moment, the Center for the Structural Constitution has just been launched at Texas A&M, and their mission is similar to the National Constitution Center's, namely to bring together the best liberal and conservative scholars of diverse perspectives for civil dialogue and debate, and to explore areas of agreement and disagreement about the constitutional issues at the center of American life. So we're really excited to have them as a partner, and in particular, I want to thank the great director of the center, the inaugural director, Katherine Mims Crocker, her faculty co-director, Neil Siegel, and the director, William Robert Payne. Katherine Crocker and Neil Siegel were law clerks for Justice Ruth Bader Ginsburg and Antonin Scalia. And they are modeling that great Scalia-Ginsburg partnership celebrated in the opera Scalia-Ginsburg and throughout our Supreme Court history. And we just couldn't imagine better partners for today. And therefore, it is with great pleasure that I introduce the great dean of Texas A&M, Robert Abeyta, to tell you more about this great collaboration. Robert. Thank you so much.
I feel like with that dynamic introduction, I want to begin with howdy. Oh, we got a few Texans here. Okay. Let me, speaking of Texas, begin with sort of asking us all to sort of reflect and think for a moment about the search and rescue efforts that continue in Central Texas, including for these young girls that disappeared from Camp Mystic. They're in our thoughts and our prayers, and we really obviously hope for their safe return homes to their families, and are obviously thinking of all of those families that lost members of their family. So this, as Jeff said, is really an incredibly exciting partnership that we're excited to celebrate. As Jeff mentioned, when we ran into each other shortly before First Monday, this past October at an event in Dallas, and I mentioned this idea of a collaboration between our new Center for the Structural Constitution and the National Constitutional Center. Even I didn't think that as soon as this spring we would be celebrating that partnership with this inaugural recognition and review of the Supreme Court term. So I'm incredibly excited about the partnership for that reason. I'm incredibly excited about the panelists that my colleagues have brought together for this wonderful event. I want to particularly mention Fred Smith, my former colleague at Emory Law School, years ago at an event not unlike this. We were celebrating the centennial of Emory Law School, where I was the vice dean and Fred was on the faculty at the time, and we did an event at the National Center for African American History and Culture in DC, in which he did an incredible, masterful job of interviewing the late Congressman John Lewis. And afterwards, as we wished John Lewis well and sent him off in his car, I said, the worst thing that you could say to a distinguished scholar like Fred Smith, I said, one day you will be a dean. Luckily, he's avoided that fate in the years since, so I'm glad, and I hope that continues. I'm most excited about this event, though, because it really is a reflection of what we are trying to build at Texas A&M University School of Law. A decade ago, Texas A&M was an unranked law school. Today, it's ranked 22nd in the country. We've seen the largest increases in student quality of any law school in history, the largest increase in student outcomes. But really what has driven this incredible trajectory of the law school have been this just amazing group of faculty, more than 50 faculty that we have recruited over this last decade, including a number that you will hear from over the course of this evening. My colleagues who are just incredible scholars, incredible teachers, incredible and thoughtful folks. And so I'm excited because this event reflects that. I'm also excited because, as Jeff described, it reflects the mission, not just of the center, but of the law school as a whole, to be a place where diverse ideas, diverse perspectives, diverse opinions can be reflected. There's not a lot of that happening in the United States right now, and I think it's fair to say not a lot of it happening in Texas either. We are excited to sort of try and be the exception to that rule, and really to ensure that as a nation, as a community, as scholars and as policymakers and as citizens generally, we are engaging one another in this dynamic way. And so I'm incredibly excited to be here with you all tonight. I'm incredibly excited to learn from my colleagues and the other faculty here. And so please join me in setting this program in motion tonight. Thank you.
Thank you, Jeff and Bobby, for those wonderful introductions. And thank you to the National Constitution Center for giving us, the Texas A&M Center on the Structural Constitution, this opportunity to partner with you. Thank you for all of you being here tonight. We're really excited to get started talking about the Supreme Court. So for our first panel, we have 45 minutes, and I could definitely spend 45 minutes just giving you the highlights of everybody's resumes. I'm going to try to do it faster than that. And then we're going to move on to, we're sort of like the classic Supreme Court review panel. So we're going to be talking about some of the sort of big top-line merits cases from this year, and we will leave questions about the shadow or emergency docket and what it is and what's been going on there for mostly the next panel, I would think. Okay, so first we are joined by Frederick Lawrence. He is the Secretary and CEO of the Phi Beta Kappa Society, and he is a distinguished lecturer at Georgetown University Law Center. He is also the previous president of Brandeis University and dean of the George Washington University Law School. So we're really honored to have him with us. And we also have Jonathan Adler, who has just recently moved to William & Mary Law School, where I worked for several years before going to Texas A&M, so please give my best to everyone in Williamsburg. Jonathan is the Tazewell-Taylor Professor of Law there. He was previously a law professor at Case Western Reserve University School of Law. He is a prolific scholar and media commentator, and in particular for this crowd, you may know or be interested to know that he's a regular contributor to the Vladeck Conspiracy legal blog. Also potentially of special interest to this crowd, he is originally from Philadelphia, so a hometown scholar. Next we have Sarah Isgur, who is an editor at The Dispatch, which recently acquired SCOTUSblog. She is host of the Advisory Opinions podcast, a contributor for ABC News, and I think most importantly of all, a native of the great state of Texas. So she was just giving us barbecue tips in the green room. And then we have Dan Epps, who is a professor of law at Washington University in St. Louis School of Law. He is a nationally known expert on the Supreme Court, where he clerked for Justice Kennedy. He is co-host of the Supreme Court-focused Divided Argument podcast, which is now also a blog. I don't know if you're a co-host of a blog or how you would put that exactly, but a great source for news and commentary on the court. And I'm excited to hear from all of them. They will each be discussing one or two cases for the term. So we'll have this sort of a conversational style, and we'll get started with Fred.
Katherine, thank you. And may I just say, you left out the most important part of my bio, which is that I've been privileged to be part of this program under prior management for 10 years, or 10, 15 years here at the National Constitution Center. And it used to exist as a conference call. The first one I did was in 2001. So this is 25 consecutive years, which I think means I get a special pin or something like that. But it's wonderful to be here under new management. Thank you, Texas A&M, and thank you, National Constitution Center. The two cases that I'm going to talk about briefly involve religious freedom and the Establishment Clause and what the court used to call the play in the joints between the Free Exercise Clause of the First Amendment and the Establishment Clause, and we'll have to dwell just for a moment on whether there still is a play in the joint between the two clauses of the religion clauses of the First Amendment. So our first case, Mahmoud against Taylor, involved a decision that was made by Montgomery County, Maryland, near my adopted hometown of Washington, D.C., who was concerned that their diverse population, including an LGBTQ population, was not properly represented in the academic program in their K-12 program, including in the elementary school, and so they wanted to add additional works into the curriculum, including one particular book called Uncle Bobby's Wedding. Now, if you want to read Uncle Bobby's Wedding, I have, but I don't have, my kids are too old and my grandkids aren't up to it yet. The reason I could read it is that it's in the US reports. Uncle Bobby's Wedding was excerpted in the majority opinion by Justice Alito for 6 justices and reprinted in full in the dissenting opinion of Justice Sotomayor. So give me, should we stop right there? Give me 30 seconds to tell you about Uncle Bobby's Wedding and the fact that it's interesting that the majority and the dissent don't seem to be able to agree on what the facts of the case were. And that's actually relevant to what we're talking about here. Uncle Bobby's Wedding is a book about a young girl named Chloe and her favorite Uncle Bobby. Uncle Bobby's getting married, and Chloe is very concerned about losing her favorite uncle. Over the course of the book, most of which is pictures, she discovers that she's not losing an uncle, she's gaining a second uncle. Uncle Bobby is marrying his boyfriend, Jamie. Arguably, a child reading that book at a certain age would miss the same-sex marriage piece and would get the Chloe losing her uncle piece of the story. Other children would take it in different ways. That's at least was my take on it. But of course, my take on it is not really what's relevant. And I'm not sure the justice's take on it is relevant either. What might really be relevant is what the teachers or parents take on it. So the case arises from the fact that parents in the school district said that they didn't want, some of them, didn't want their children exposed to certain kinds of books, and so they wanted the right to opt out from those books, or opt out of their children being present when those books were being read, but they wanted to be notified in advance when certain books were being read. Initially, the school system said they would do that, and then it became administratively unworkable, or so they said. And so they said they couldn't do that anymore, and so they would just have these books as part of the curriculum. Parents could respond at home as they wished. It was challenged on grounds of religious freedom, and the majority of the court, in an opinion by Justice Alito, articulates the religious freedom argument using Wisconsin against Yoder, a 1972 case that some of you will recognize as the Amish education case, that forcing Amish children to go to a secular school would be a violation of their religious principles. And Justice Alito says, similarly in this case, this would be forcing children to violate their religious principles. It's a violation of the free exercise of religion of the families. Justice Clarence Thomas concurs and adds a reference to Pierce against Society of Sisters, a 1920s case involving the Oregon law years ago that would have required everyone to go to public school. It would have been impossible to have parochial schools. The history of that case probably suggests that that law really was an anti-Catholic school statute. The court struck it down in a unanimous opinion by Justice James McReynolds. If you have a taste for irony, James McReynolds is probably best known today for being the most vicious anti-Semite who ever sat on the United States Supreme Court. He refused to shake hands with Louis Brandeis and even refused to sign the letter to Brandeis when he stepped down from the court, congratulating him on his tenure. But I digress. The dissenters, in an opinion by Justice Sotomayor, say that public schools are schools that are more than just educational institutions, they are civic institutions. They're the ways in which children are exposed to a wide range of views, a wide range of opinions, and that it would be administratively unworkable for every conceivable religious group, every conceivable group in society to get advance notice about different pieces in the curriculum. If parents want to object to something in the curriculum, they can certainly take it up with the teacher in conference time. They can take it up with their own students and talk to them about it in the morning and in the evening. And of course, they can also take their kids out of those public schools and send them to private schools. The fact that there's thunder right now may or may not be relevant to what I'm saying. So a 6-3 decision upholds the religious argument of the parents who claimed that their children should not be required to be in class when those books are read. One last piece, particularly for the lawyers in the room. Technically, what I said is a little overstated because the procedural posture of this case is an injunction that was denied below that now is granted by the Supreme Court. So really all the court said is there's a likelihood of success on the merits for those parents. But I think we can read from that what the court's view on this decision would be. The other case, I think, will take us less time to talk about. It's a 4-4 decision because Justice Amy Coney Barrett recused herself, and so the decision of the court is really a non-decision. It affirms the decision of the Oklahoma Supreme Court by an equally divided court. This was a decision in Oklahoma that, applying the Oklahoma Constitution and an Oklahoma statute, said that a charter school could not be a religious institution. Oklahoma has a charter school program. There's a board that certifies charter schools, and there was an overtly religious institution that sought a charter school that was denied. They challenged us on religious grounds. What makes this case particularly interesting, and we don't get a decision this time, but again, it goes back to this play in the joints, and we see the issue is, on the one hand, do we say that if Oklahoma is going to have a charter school system, which of course they don't have to, but if they do, then they can't discriminate on religious or non-religious institutions. That's what the dissenters in the Oklahoma Supreme Court said, and 4 justices in the Supreme Court must have said. We don't know who they are, a great parlor game in Washington to guess who's in the 4 and who's in the 4. Now that one definitely wasn't a coincidence. In Washington, D.C., to guess who they are for an equally divided court. Undoubtedly, Justices Thomas, Alito, and Gorsuch, and almost certainly Justice Kavanaugh, although we don't know. Or do we say, as the other 4 justices must have said, undoubtedly Justices Sotomayor, Kagan, and Jackson, and probably the Chief Justice would be the 4th, do we say that Oklahoma is permitted under the Establishment Clause and under its state Establishment Clause to say, no, the religious institutions are different and we don't fund religious institutions and have religious charter schools. So it really depends on whether we see this as an Establishment Clause case straight up, in which case it does, in traditional terms, appear to be an establishment of religion to have an official public funding of a religious charter school, or do we look at it as a free exercise cum discrimination case where religious institutions are being treated differently? Probably the best thing we can say on an opinion that comes out 4-4 is stay tuned and watch this space for further developments. Maybe, because we don't know why Justice Barrett recused herself. It may be that given her own family circumstances and belief structure, she thinks these are the kinds of issues, this particular issue is one she will have to recuse herself on. Wait and see, come back next year, and we'll find out together.
Thank you, Fred. Well, so I'd love to ask you if you wouldn't mind making a prediction about where the court might be heading on religion clause issues in general, or maybe in particular about what might be going on with employment division versus Smith, which the court sort of set aside in the Mahmoud versus Taylor case. And I'd love to hear from any other panelists on this question as well.
Again, for one's taste for irony, employment division against Smith is a Justice Scalia opinion, in which he articulates the view that a neutral decision, a neutral, generally applicable law that incidentally affects religion does not raise a religious freedom case and does not get strict scrutiny. Had that been applied in the Mahmoud and Taylor case, if the argument there is that, as Justice Sotomayor said, there's actually not a religious freedom argument here, this should be evaluated on a basis of rationality Is there a rational basis to what this school system is doing? Because there's no religious freedom argument here, given that it's an incidental impact on religious practice. I think if one had to bet, first of all, that case comes down 6-3, taking employment division close to the vanishing point. And then I think predicting how a 4-4 case would come out if the ninth justice is added back is always a risky business. But based on where the court has gone, the court has shifted away from a jurisprudence that looked much more heavily on the Establishment Clause. And as Justice Sotomayor said in dissent, not this term, last term, the Establishment Clause appears to be reaching the vanishing point. Because if we look at claims as saying we can't treat religion differently, then states that do any particular conduct have to treat religion the same way with respect to that. The argument used to be that we treat religion differently because the Establishment Clause of the First Amendment says we have to treat religion differently. But if we take it out of an Establishment Clause analysis and put it in either to a free exercise or a free speech analysis, as the court has done in prior cases, then the play in the joints may be replaced by the ever-shrinking, vanishing Establishment Clause.
Thank you. Anyone else want to chime in on where the court seems to be heading in the Religion Clause area?
I guess I would just say historically, to your point, what we had 70 years ago and before that was a problem of government favoring some religions over other religions, which is why I think you see a very robust Establishment Clause in the middle of the 20th century. The problem we have now, of course, the argument would go, is that we have religion versus non-religion being favored, which is why you see the Free Exercise Clause becoming much more robust here in the 21st century. So I think culture explains as much of the difference as the court because of the laws and state funding actually being disputed.
Possibly. The question is, does the greater power include the lesser power, right? The greater power is the power to say we're not going to have charter schools at all. State can certainly do that. But does that include a lesser power to say we're going to have charter schools, but this is how they have to apply with respect to religion? The court seems to be saying, no, in this case, you have the greater power, but you don't have the lesser power.
Right, and in the Establishment Clause context, though, it would be if you have the charter schools, you can't allow Catholic charter schools, but not Jewish charter schools. But under the Free Exercise Clause, if you're having charter schools, you can't say we have secular charter schools, but not religious charter schools.
And that may be a shift in, well, when you say culture, I think then it begs the question of which part of the culture. I mean, there's clearly very different views on how religion ought to play a role, not in societal life generally, but in public life and in publicly funded life. And I think it still begs that question.
Thank you. All right, so let's move on to Jonathan. Jonathan's going to be discussing United States versus Skermeti, and hopefully you'll tell us why it's called United States versus Skermeti.
I will, and I want to connect it to the cases we just heard about a little bit, because I think one thing that we see in the Mahmoud case in particular, and Skermeti as well, is the court avoiding confronting broad claims about parental rights as parental rights, and rather trying to deal with cases that implicate parental rights in other ways. So in the Mahmoud case, by focusing on the parental right to direct the religious upbringing of children, not parental rights more broadly, and then as I'll explain in a moment, in Skermeti, avoiding the parental rights claim altogether. So the Skermeti case involves a statute, a state statute from Tennessee, which about half the states have equivalent statutes that prohibit the use of puberty blockers, hormone treatments, and surgery for sex transitions for youth, for minors, without regard for whether or not a doctor has prescribed such treatments, without regard to what the wishes of the parents are. So Tennessee, again, like approximately half the states in the country, has adopted such a law, and some families challenge that law. And they initially raise two sets of claims. One set of claims is a parental rights claim. As parents, we have a right to direct the upbringing of our children if we believe, with the doctor's cooperation or a doctor's approval, that these sorts of treatments are appropriate for our children. The state should not be allowed to interpose itself in that. And then a second claim, which is an equal protection claim, which is to say these laws are barring treatments for
certain children with certain gender identities or seeking certain sex-related outcomes, and that violates the Equal Protection Clause in one of a couple possible ways. The United States joins this case on the equal protection claim, not on the parental rights claim. And the parents lose in the U.S. Court of Appeals for the Sixth Circuit, and the United States files a petition for certiorari solely on the equal protection claim. That is the petition that is granted. The ACLU, on behalf of the parents, files a petition for certiorari on both the equal protection and parental rights claims. After the Scrimeti case is decided, the parental rights claim certiorari is denied. So the court takes up this question solely on whether or not the Tennessee statute violates equal protection. And there are kind of a couple ways of, or slices at this question that the court engages in. By a vote of 6-3, the court ultimately upholds the law, says that the state law does not violate the Equal Protection Clause of the 14th Amendment, in an opinion by Chief Justice Roberts. And it goes through several steps. The first is to say this is not, this law which prohibits these treatments for these diagnoses in youth is not a classification based on sex. And some of you may seem to be puzzled about that, because a few years ago there was this case called Bostock, where in a different context involving Title VII of the Civil Rights Act, a majority of the Supreme Court had held that discrimination against an individual because of their transgender status was discrimination on the basis of sex for the purposes of Title VII. Supreme Court in Scrimeti says that the Equal Protection Clause does not have the same text as Title VII. That's not the basis. And the Chief Justice says that what the statute is actually doing is drawing a distinction based on age, because these treatments are prohibited to youth, to minors, but not to adults, and based on medical treatment. That is to say, throughout the regulation of medicine, we typically think of particular procedures or particular medications not merely as things you do or as substances, but as things that are prescribed or administered for a particular purpose, right? So when you approve drugs, you approve them for a particular purpose. That's why we have a whole area of off-label usage. And so the Chief Justice's opinion says those are the distinctions the statute draws. So we don't have to answer the question whether or not this law would be constitutionally valid if we thought it was drawing a distinction based on sex and therefore triggering intermediate scrutiny. Instead, we can say it's just drawing a distinction on these other bases and can be subject to rational basis. Chief Justice also says, for 5 of the justices, Justice Alito does not join this part of the opinion, that the statute is not drawing a distinction based on transgender identity or transgender status, again, based on youth and on treatment. Justice Alito was not convinced by that, so did not join that part of the Chief's opinion. So the court did not have to confront the question of whether or not a law that expressly distinguishes between transgender individuals and others would trigger any form of heightened scrutiny as a quasi-suspect class. But a quick spoiler alert, the court has 2 cases on the docket for next term where it's not going to be able to duck that question in both of them, because one of them, these involve transgender participation in women's sports, and the court has taken 2 cases on that next term. So the Chief Justice basically says this is state regulation of medical treatments focused on youth. That's something we let states do all the time. We apply rational basis. That just requires the state to have essentially a plausible justification for what it's doing. There's a lot of debate about the value and safety of these treatments for children. That's really an easy call. Justice Barrett writes a separate opinion joined by Justice Thomas saying, well, if we were to ask the question, are transgender individuals a suspect class that would trigger heightened scrutiny, we would have said no. And Justice Alito, in his separate opinion, also says that. So we know there are 3 justices that would have simply said, we have strict scrutiny for race, we have intermediate scrutiny for sex, but transgender status does not trigger heightened scrutiny. We just apply rational basis. 3 justices not taking a position on that question this year, but presumably will have to next year. And then 3 justices in dissent. The dissenters, interestingly enough, all 3 of them rejected the majority's view that this was not a statute that should be subject to heightened scrutiny. But only 2 justices, Justices Sotomayor and Jackson, were willing to say the statute would fail that test. Justice Kagan did not join that portion of Justice Sotomayor's opinion, saying instead, this is such a detailed, complicated, fact-bound area of law, it's quite possible the state would be able to satisfy this higher level of scrutiny, and we should send it back for that. So on that part of it was 7-2. I already noted how narrow the opinion was. I think there's two ways of interpreting this, right? One is, that's the Chief Justice's specialty. He likes to put together majority opinions that are as narrow as he can convince 5 justices to agree to. And as we know in recent years, sometimes he's able to do that, and sometimes he's not. He's on a court with a lot of folks with strong opinions of things. The other possibility is that on this particular issue, the Chief Justice was trying to avoid having to answer these questions about are classifications based on transgender status for constitutional purposes in effect classifications based on sex, and or do such classifications on their own require heightened scrutiny. It may just be that those are particular questions he did not want to answer, but as as already mentioned, there's a circuit split on those questions. The court has 2 cases for them next term, so we're gonna find out the answer to what the court thinks on those questions pretty soon.
Great, thank you. So I wanted to circle back to something that you mentioned in the beginning, which is the parental rights argument. You mentioned that the court avoided that here by not granting cert on the question, but where do you think that the court might be heading on that issue? Is that something we're going to see the court sort of grapple with head on? And maybe you can talk some about like the connection to substantive due process, right? And the sort of different political valence that can have.
It's a fascinating question about what they'll do. I think one of the reasons the court hasn't addressed it is because depending on the case, it cuts in different directions. So in the Scrimetti case, we might see that parental rights skewed in what we might characterize as a progressive direction in the sense that it was in favor of parents getting treatment for youth with gender dysphoria to allow them to get these treatments. There's a case next term that the court has only accepted on First Amendment grounds involving something that's referred to as conversion therapy. So psychiatric therapy for youth to help them, I don't know the best way to describe this language yet. Right. But basically parents that think their children are incorrectly believe that they are gay or incorrectly believe they are transgender. Some states have banned psychiatric treatment for minors for that purpose. The court has only accepted that on the First Amendment grounds, but there the parental rights claim arguably cuts in the opposite direction. So I think the justices don't really know what parental rights leads to. It also, parental rights claims, if they're not tethered to religion, rely upon substantive due process. And we know post-Dobbs, a lot of justices really don't like substantive due process, think that's something that Pandora let out of the box and they want to put it back away. And so I think that the justices are kind of afraid of that question because on the one hand, there are both very strong progressive arguments for parental rights, very strong conservative arguments, family-based arguments for parental rights. But once you let that go, who knows where it goes? And so I think it's fascinating that there are all these cases that implicate parental rights, and the court's trying to resolve them on something other than having to turn to due process.
Yeah, really interesting. Thank you. All right. So Sarah, being from Texas, has agreed to talk with us about guns and about a case coming from the Fifth Circuit.
Love the Fifth Circuit. Clerked on the Fifth Circuit. Fifth Circuit was the circuit with the most decisions overturned this term, which is interesting, of course, because it's the most conservative circuit. So in some ways, the Fifth Circuit is the new Ninth Circuit. And I think it says something about where the court is and the assumptions that people made about what a 6-3 court would really look like. So in many ways, my case is boring. And so we're going to use it as like illuminating larger themes about the court. This was a 7-2 decision about whether the Gun Control Act that Congress passed that allowed the ATF to regulate any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, yada, yada. The ATF then used that statute to regulate so-called ghost guns. These are the gun kits. They're like Legos, but they make Glocks. And they're increasingly used in crimes because you don't have a serial number, you can't trace the gun, very hard for police to catch you, very good for crimes. Or for father-son bonding, I guess, as a student at Columbia raised his hand and told me. Takes all kinds, y'all. So 7-2, the court said, look, the statute's pretty clear. We think the ATF is given authority to do this. This was a facial challenge, meaning that it was not about any particular gun kit. It was whether the ATF whether there was any gun kit that the ATF would be able to regulate with this power. So 7-2, they said, yes, it's an opinion written by Justice Gorsuch with Justice Alito and Thomas, both dissenting. As I said, I mean, that was really quick, right? We're done with the case. But I thought we could talk a little bit about Justice Gorsuch potentially being one of the more interesting justices on the court. So just to run through some stats here from this term on the opinions of the court, 9% had the 3 liberals in dissent, and 6% had the trio of Gorsuch, Thomas, and Alito in dissent. Now, if you include the 5 Forbes as well, that's 15% with all 3 liberals in dissent, and 15% with only conservatives in dissent. So it's sort of like the Fifth Circuit, right? If you're too far to the right, they're not going. And if you're too far to the left, they're not going. The center of the court has probably shifted a bit to the right, but it is not all the way to the right by any means. Justice Gorsuch is a really interesting part of that Thomas-Alito-Gorsuch threesome because he doesn't quite fit in with them. He is far more libertarian. He writes the most separately. He wrote 3 solo dissents, just Gorsuch by himself, nobody else is with him. And he comes by his dislike of the government honestly. If you remember, his mother was the director of the EPA, that Ann Gorsuch, director of the EPA, refuses to turn over documents to Congress, then Reagan changes his mind, tells her to, she resigns amid the turmoil, yada, yada, yada. Morrison v. Olson, where Ted Olson is then being investigated by an independent prosecutor at that point, which is like one of the biggest separation of powers cases. So Gorsuch, David French came up with this to explain Gorsuch and how you can guess how he's going to come out in any given case. He votes against the bully. A lot of the time, the bully is going to be the government, but not always. If you've brought your case in bad faith or some other such thing, that's fine. This is kind of a good example of that. You're making a Glock and then sending someone a Glock minus a screw and then sending them the screw with instructions for how to put the screw in, and it takes about 25 minutes to file something down. Justice Gorsuch is like, are you kidding? This isn't even a real argument. Also, this is one of those cases where he breaks from Thomas and Alito. So it's 7-2. We saw an unusual number of 7-2 decisions this year. Most of the time, it was Kagan joining with the 6 conservatives. But this was sort of a fun example where Gorsuch breaks from Thomas and Alito. We've seen that happen before in other high-profile cases. Gorsuch and Thomas break over Bostock, the case that you mentioned earlier about employment discrimination. Gorsuch and Thomas break over Rahimi, a Second Amendment case about domestic violence restraining orders in the Second Amendment. And they break over, what was that? Oh, and here, obviously. So I think Justice Gorsuch, Justice Barrett gets all the attention as the most interesting justice in the world, and she is, and that's great, and of course it's fascinating. But Justice Gorsuch is sort of your sleeper interesting justice because he's part of that most conservative wing. But where he breaks against the government. And that makes him at least the second most interesting justice.
Thank you, Sarah. Well, I'm interested to hear what other people think about, sort of this perennial question among commentators, but maybe what this term says about it. Do we have a 6-3 court? Do we have a 3-3-3 court? Maybe in some cases we have a 7-2 court where Justice Gorsuch is, with the left side in the middle of the court. And then, a piece of pushback that people will often give to someone who says, we have a 3-3-3 court, it's not a 6-3 court, or something like that, is that you can't just look at what the outcomes are, right? You have to look at what cases the court is choosing to hear, and how that sort of shifts the Overton window on the court. So I'd love to hear any responses to that. You want to start, Sarah?
I just get in like a little bit of a rage about the like, yeah, but for the big cases, it's 6-3, because if you notice, most of the time people define the big cases after we get the outcome. So they wait until it's a 6-3 outcome with the liberals on the dissenting side and then say, look, it's a big case. We had a day where we had 3 unanimous opinions written by Jackson, Sotomayor, and Kagan, and they were, I mean, aptly dubbed the God, Gays, and Guns cases. So I find the big cases, at least, to be a frustrating way of looking at the court. If you want to send me a list of your big cases at the beginning of the term before you know the outcome, then I think we can discuss those, pick our big cases, and then see how they turn out. But in last term, we had the court upholding Section 2 of the Voting Rights Act. So it wasn't a big case anymore because they upheld Section 2, but it would have been a big case if they hadn't. I find that sort of ends justification frustrating, even though I don't think 333 is perfect by any means. I don't think 6-3 is either.
Thank you. Anyone else want to jump in here?
So I would gently push back on the idea that we can sort of categorize the court as more conservative, less conservative by looking at whether they're reversing the Fifth Circuit or not, in part because we have to also think about how the ball has moved in the lower courts, right? To the extent that the Fifth Circuit is really going out and taking positions that would have been not conceivable or really not considered plausible positions 10 years ago, yeah, the court could still be moving quite aggressively to the right while still stamping out outliers that are even further to the right.
I think something that it's definitely true about that is that the Fifth Circuit has had a knack for teeing up cases that the court has to take, right? So generally, for example, if a federal statute is struck down, federal program is held to be unconstitutional, the court's taking that case. And the Fifth Circuit's been more aggressive in teeing up some of those, and in some cases has gone farther than the court's willing to go. But we've seen a remarkable number of cases that, and this relates to Sarah's point, that before we got the decisions, people talked about certain cases that they might be big cases or they might be divisive cases, and they come out 9-0 because as of legal questions, they were actually quite easy, and it was courts that were outliers in the other direction that had just kind of not decided to do their homework in terms of reading the applicable precedent. The case involving from the Sixth Circuit about whether or not there's a different standard in employment discrimination cases based on whether the person claiming discrimination is part of a relevant majority or minority racial group or sexual group or whatever else. I mean, there was no way to read the relevant case law to say that there is a different standard. The state wouldn't even defend that position when it got to the court, and a lot of people talked about that case as if it was going to divide the court. And no, it was 9-0. But it was 9-0 because the law was relatively clear on that. But I think the last thing I'll just say is, as the court's docket is shrinking, we're getting a higher percentage of cases coming for the court that are outliers in one direction or another. The court's spending a lot more time kind of cleaning up outliers, and it's not taking the extra 24 cases it would have been taking 15 years ago that would have given us a fuller picture of kind of the sorts of questions before it. And I'm among those that think that's a problem. There's plenty of work, plenty of cases for them to hear, and the 9 of them could handle more than 50 a year.
That's just worth also underlining that a court that gets to choose its own docket is going to be very hard to draw trend lines about, because you have to start with which cases they're accepting or rejecting in the first place before you can get to what opinions they're issuing.
I think the first big surprise for anyone clerking on a court of appeals is the sheer number of cases that are not only 3-0 on a panel of 3, but sort of straightforwardly 3-0. And that's a court that can't choose its own cases. So when a court can choose its own cases, you get these sort of highlighted differences. But at the risk of being a little bit of the skunk at the picnic here, they all sort of, there's a lot more agreement than we think. There is a tone of some of the dissenting language and the response to dissents that has been a higher temperature than we've seen maybe ever, or certainly in some time. Justice Sotomayor has become the master of the phrase before the I dissent. I mean, it used to be I dissent or I respectfully dissent. But now we have a whole series with Fear for Our Democracy, I dissent, from last term, and several of those this year. And of course, in the birthright citizenship case, the back and forth between Justice Barrett and Justice Jackson, which for court watchers was nothing short of stunning, that kind of ad hominem language from justices who, certainly in the case of Justice Barrett, we don't think of that way. Justice Jackson's a little new to the court to actually know what we think of or don't think of. So we'll see where this goes in future terms, but this is not 9 people all singing from the same hymnal at this point.
In Skermiti, I think that Justice Sotomayor said, "In sadness, I dissent."
Yes.
So this discussion about the court's shrinking docket and how it's taking fewer cases is a good segue to Dan's case, because it's especially relevant in the criminal procedure area, where the court has been hearing fewer and fewer cases. So Dan is going to tell us about a case that I think he told me he thinks is the most interesting crim pro case of the term. I'd love to hear what you think about it.
So one thing I've been quite interested in as the court's membership has shifted over the last 8 years is how is the criminal procedure case law going to look different? And in part, that's because I teach in those areas, and it bears directly on how much more work I have to do in terms of prepping my notes. But I think that the court has long had an important role in kind of reining in some of the excesses of state criminal justice. And my question was, as the court moves in a more formalist direction, are they still going to be willing to kind of, again, stamp out those outliers? I think my thesis had been, in some writing I'd done, that that's what it's going to look like. Criminal procedure is not going to be in full bloom the way it might have been even during the Kennedy court, where Justice Kennedy would sort of bring a sort of sense of fairness, in a way that was not as tied to kind of like the minutia of the original understanding of particular constitutional provisions. This case, though, Glossop versus Glossop versus Oklahoma, is a slightly different data point that maybe cuts in the other direction, in that it looks like sort of one of these older cases where the court comes in, kind of speeds over some procedural and substantive roadblocks just to seemingly get at the result that seems kind of just to people. And very long procedural and factual history. The case has bounced around in the federal court system and the state court system for decades. It's based on a capital murder charge from a killing in 1997. The defendant, Glossop, has been twice convicted. The first trial was overturned. It's a murder that everyone acknowledges he didn't personally commit. It was committed by a guy named Justin Sneed. And Sneed at one point, basically became a witness for the state and said that Glossop had paid him to commit the killing. And this was really the key and really only piece of evidence tying Glossop, other than some circumstantial evidence, tying him to the killing. And it's a case that has kind of became a cause celeb. There's been a lot of talk about how a lot of kind of procedural unfairness happened at the trial. There have been multiple independent investigations that have occurred. One was commissioned by the legislature, one was commissioned by the Attorney General's office, and that have concluded the trial that led to his current incarceration and death sentence. Was riddled by various forms of procedural irregularities and unfairness. What really sets this up, though, is this is one of many, many rounds of back and forth in the state court system. The defendant finally got his hands on this box of evidence that the state had been holding on to for a couple decades, basically. And in that box, there was a note. That was a note taken by one of the prosecutors of an interview with Sneed, the key witness. The note is a little cryptic, but the sort of maybe the most plausible reading of it is that in it the witness indicates that he had been prescribed lithium by Dr. Trumpet, who is actually we think is Dr. Tromka, who is the only psychiatrist that would have been able to prescribe lithium in the correctional facility where the witness was housed. Long story short, this is the premise of a claim that the prosecutor put on false testimony because he testified that he had never been diagnosed with bipolar disorder or anything like that. And basically, this went to the state courts. The attorney general, actually, of the state said, you know what, he's right. We agree that he should win on this claim. The Oklahoma Court of Criminal Appeals said, actually, no. We think that you shouldn't have conceded error. This is not grounded in the law. It comes up to the Supreme Court, and the Supreme Court, decides, in an opinion by Justice Sotomayor, to issue a win for the capital defendant, and kind of as broad a win as you might see, in a way that really struck me as kind of surprising. And it did so by kind of, I don't want to say running roughshod because I think the court, made good arguments, but proceeding past a number of speed bumps. So the court said, yes, this is not clear, but we think that the state court decision was grounded in federal law, right? The Supreme Court can't rule on an issue of federal law if there's an independent state ground that prevents that issue from being reached. The court says, no, we're going to read this as a resolution of a federal question. And the court then says, the state court misapplied federal law about when it's a constitutional violation for a prosecutor to put on false testimony from a case called Napew. And then goes further and says, beyond that, we're going to just look at the evidence ourselves, and we're going to just decide that this actually was a constitutional violation. Maybe the facts could be read different ways, but we think, no, this is just a constitutional violation, and actually we're just going to order a new trial right now. Justice Barrett writes a partial concurrence, partial dissent, in which she says, look, I agree that the state court misapplied the law. I agree that there is federal jurisdiction here, but the court is going way too far in just declaring this is actually resolving the disputed factual issues and saying the remedy is a new trial. That majority opinion is Justice Sotomayor, joined by the other liberal justices, and joined by Chief Justice Roberts and Justice Kavanaugh. And then you have a fairly predictable dissent by Justice Thomas, joined by Justice Alito, and Justice Gorsuch is recused because he had previously ruled on an earlier issue in this case when it was coming up through the 10th Circuit more than a decade ago. So I just find the case really interesting because it suggests maybe there still is some appetite for the court to come in these cases that get the most attention, which there are a lot of people saying, look, there's a lot of kind of smoke around this case. We think that this guy got a really raw deal, and at least a couple of the conservative justices are willing to say, okay, let's just fix this. I think that would have happened more often, 10 years ago, but maybe it's still going to happen occasionally.
Yeah, really interesting. So that sort of leads into my question. I was wondering, do you think that this case is sort of unique in the sense that you have, the Attorney General's office confessing error, and that's why the case came out the way it did? Do we think this is like a one-off, or do we think that there's important implications for, criminal procedure more generally, or what people call the death docket at the Supreme Court? If you, maybe want to tell us what that means, the death docket?
Yeah, so the court is, one of the most significant things the court does in the kind of shadow docket or the emergency docket is to rule on these last-minute procedural requests, requests for stays of execution by capital prisoners. Almost all of them are denied, but that's just an important part of the court's job. It's an important part of law clerk's job at the court to kind of be there until midnight to rule on these things. I don't think this portends a radical change. Those last-minute stay requests are overwhelmingly denied, so I don't think that suddenly next term we're going to see many of them being granted and the court taking a bunch more of these cases. Maybe you can say it does suggest that somebody like Justice Kavanaugh is not going to be quite as formalist in some of these crim pro cases. He's willing to maybe make the kind of Gorsuch move of saying, who's the bully here? And maybe there's going to be the occasional case that gets so much attention where at least a couple of them will say, not here. Another example of that is the Flowers case from a few terms ago, where the defendant had been tried and convicted 6 times, and he kept getting his convictions overturned, and finally the Supreme Court said, too much, like just let this one go.
Yeah, you. All right, we are over time, so if you all would join me in giving our wonderful panelists a round of applause. Thank you all. All right.
Good evening. Good to be with you all. My name is Neil Siegel, and I am a professor of law and co-director of the Center on the Structural Constitution at Texas A&M University School of Law. This session is on recent orders and decisions of the Supreme Court bearing on issues of executive power. I am joined by three able scholars and observers of the court. We have Steve Vladeck of the Georgetown University Law Center. Wave, Steve. We have my friend, and I was at Duke for 21 years. Like, this means something to me. Anyway, I am also joined by my friend and colleague, Dan Walters, also of the Texas A&M University School of Law, and Keith Whittington, a longtime professor at Princeton University, now of the Yale Law School. They're all famous, blah, blah, blah. I'm going to be very brief in introducing them. As relevant here, Steve is an expert on the Supreme Court's emergency orders docket, the so-called shadow docket. He literally wrote the book on the subject. Dan is a star in the field of administrative law, and in my humble opinion, Americans desperately need to know more about administrative law because there are great changes in the law taking place in that field that really affect the lives of you and me. And Keith has done important work on the political foundations of judicial authority, especially the relationship between the president and the Supreme Court, among many other things, which is true of each of our panelists. Our first panel this evening discussed the Supreme Court's merits docket. And what characterizes the merits doctrine is that there is substantial time for briefing, for deliberation, first on the question of whether the court is going to take a case, and if so, then on the question of how the court is going to dispose of the case. By contrast, stay applications brought to the Supreme Court on the emergency orders docket are pretty much the opposite. They ask the justices to act very quickly, without much briefing, with little time to deliberate, to undo preliminary orders issued by lower federal courts while litigation continues in them. It used to be the case that almost everything the Supreme Court did that was really important took place on the merits docket. The big exception was last-minute stay applications in death penalty cases. That's what it was like when I was at the court in 2003, 2004. That's what it was like when my colleague Katherine, who moderated our first session, was at the court a decade later. And the data bear this casual empiricism out. During the 16 years of the George W. Bush and Barack Obama administrations, the federal government filed a total of only 8 emergency applications. That's half an application per year on average. During the 4 years of the Biden administration, the government filed a total of 19 emergency applications. That's definitely an increase over prior practice, but still fewer than 5 emergency applications a year. Well, in the first 20 weeks of President Trump's second term, the administration filed 19 emergency applications asking the Supreme Court. 20. Are you talking about today?
It's 20.
Okay. Well, that makes the arithmetic easier, doesn't it? 20 emergency applications in 20 weeks. That is an average of one per week. Asking the court to put on hold losses that the administration had suffered in ongoing litigation in the lower federal courts. And there have been more emergency applications filed by the administration since that time. Indeed, the term is not over. It continues to unfold as the emergency applications continue to come in and the court continues to decide them, as it did today in a very, very important case. So I'm interested to hear what the three of you think of these and other developments in the area of executive power. I would predict that we're going to talk about only 2 merits decisions. The rest is going to be the emergency orders docket, and one of those merits decisions involving nationwide injunctions actually began on the shadow docket. Because I'm not only a moderator, but an opinionated moderator, I'm going to give you my brief take that you can agree, disagree with, or ignore. My brief take is that there hasn't been a term like this in my lifetime, in our lifetimes. I say this, I live to learn. I'm learning all the time. I take seriously the court's efforts to ensure that its decisions and orders are not defied by an aggressive presidential administration. I write about those tools of what I call judicial self-protection. But even so, I never thought I would see a term in which an administration would seek so much discretionary preliminary relief from the court in so short a time. I never thought I would see a term in which the court would grant the administration such relief so frequently. And by the way, when the biggest bully of all comes along, the Trump administration, Justice Gorsuch is not voting against the government, right? Much more often than not, none of the court's conservatives are. Even in cases in which the administration is making arguments in the lower federal courts that are either frivolous or just north of frivolous. And I'm thinking about the administration's novel interpretation of the Citizenship Clause in Section 1 of the 14th Amendment, as well as its invocation of the Alien Enemies Act in multiple cases to try and remove individuals from the country. Finally, I did not think I would see a term in which the court would grant the administration emergency relief, even in cases in which the administration came to the court with dirty hands because it had plainly defied lower court orders. And there are 2 cases in particular that we may talk about in which that is what happened. Now, to be clear, I myself am not confident that the lower federal courts have gotten the law right in all of these cases. My response to that is, what else is new? That's why we have appeals. We even have tribunals called federal courts of appeals. It used to be that when the government didn't like what a court did, it would appeal all the way up to the Supreme Court if necessary. Lawlessness, defiance, used to be out of bounds, and something that really worries me is that the court's responses to such defiance by the administration may unwittingly serve as an accelerant in the years to come. All right, enough from me. Let's hear from Steve. Steve, this is the first time in your life alphabetical order rewards you with the pole position. Then we'll turn to Dan, and finally from Keith, and I expect we'll have some time for discussion.
Thank you, Neil. 5-year-old me is very excited that I am first. So Neil basically said everything that I was going to say.
You said it well.
Well, I really did. I guess I want to make 3 points that are, in some respects, elaborations upon what Neil said, but I also want to be brief because I'd love to both hear from Dan and Keith and also leave time for us to talk to each other a bit. So the first point is I think it's worth underscoring the descriptive point that Neil gave you. It's not just that we've had 20 applications in 20 weeks from the Trump administration. It's that the court has granted, in whole or in part, each of the last 17. Including as recently as this afternoon in a really important case about the Trump administration's plan to engage in mass reductions in force across the federal government, the euphemism we have for mass firings. This is not just an aberration. Even during the first Trump administration, the success rate was not nearly as high. It is also really, I think, undermining efforts to quantify the work of the court solely by looking at the merits docket. In those 17 rulings in which the court has granted relief to the Trump administration, in all 17, at least one of the Democratic appointees dissented. In none of the 17 did any of Justices Thomas, Alito, Gorsuch, or Kavanaugh dissent. Right, and so this is not a nuanced, interesting court. This is a court that is voting straight down ideological lines in almost all of these cases. So that's point number one. Like, this is not just a big deal, it is a big ideological deal. Point number two, the court is not writing. So, Neil plugged the book, thank you, checks in the mail. But one of the real critiques that I offered about the court's increasing reliance upon emergency applications, which has now just gotten totally blown out of the water this term, is that the court really had started to grant emergency relief, to upset the status quo, to put back into effect policies that the lower courts had blocked with no explanation. And this pattern has persisted into this term. I mentioned the 20 cases, the 17 recent grants of relief. In total, the court has written 3 majority opinions in those cases. And those majority opinions, with the exception of the birthright citizenship case, about which Keith will be saying more, were very, very short. Many of these rulings are coming with not even a sentence of explanation. Even when there are lengthy dissents, even where the lower courts have said quite a bit, whether you buy the rulings from the lower courts or not, and my microphone clearly does not, right, the court not explaining itself causes all kinds of problems, not just because we don't know what they held, but as we saw in a recent case about removing migrants to third countries, the lower court and the government doesn't know what the justices have held. I mean, we had the federal government recently have to literally file a motion for clarification in the Supreme Court because its original ruling for the federal government hadn't said anything. Whether you are sympathetic to what the federal government is trying to do or not, the court not explaining itself seems like a huge problem. Point number 3, and I'm almost done. Point number 3, we're in for more of this. So one of the remarkable things that Justice Brett Kavanaugh wrote in his concurring opinion in the birthright citizenship case is that this question, what should the rule be while cases work their way up to the Supreme Court, is something the Supreme Court should be answering more often. Right? So Brett Kavanaugh promising that the emergency docket is going to be even busier, which is especially ironic when you consider that the whole point of the decision in the birthright citizenship case was to not answer the question whether the policy is actually unlawful. So more emergency rulings, less clarity. That's not a good combination. And this leads me to my last point, and I think this is where we get to the theme of the panel, which is executive power. By not writing, by issuing so many rulings that are putting policies of the Trump administration back into effect, by dividing along ideological lines, there is increasingly no other way to describe what the court is doing in these cases than enabling unprecedented claims and assertions and accretions and aggregations of executive power. Not necessarily because the court is endorsing in the long term everything the Trump administration is doing, but because the court is enabling in the short term everything that the Trump administration is doing. The only case where the court pushed back, one of the Alien Enemies Act cases from April, in retrospect, looks like a case where the court pushed back not because the justices were so worried about the due process rights of the migrants who were about to be removed, but because the justices were pissed off that the Trump administration seemed to be defying their own mandate. That is, those of you who are familiar with European history will recognize a word for this kind of behavior. It's called appeasement. And I really do think that one way to understand executive power vis-a-vis the Supreme Court right now is that at least some members of the court may not see themselves as, but are very much acting like Neville Chamberlain. And by the way, I love that I say Neville Chamberlain. You guys all know who I mean.
Well, when we get to the Q&A, Steve is going to tell us what he really believes.
The Mets don't have enough pitching.
Dan, the
floor is yours.
Well, it's a tough act to follow, but it's great to be here at the National Constitution Center. It's a full circle moment for me. I used to live 2 blocks from here, so this is quite exciting.
Does that make you a Phillies fan?
I am a strong Phillies fan, yeah. Oh yeah, go Phils. So actually, where Steve left off is a good segue to what I wanted to talk about. As Neil mentioned, I'm an administrative law scholar. I'm a bit of an interloper here at a constitutional center, although increasingly administrative law is constitutional law. They're really overlapping, and this is a court that is keenly interested in administrative law and using constitutional law tools to make major reforms in administrative law. So I'm going to cheat a little bit and talk about one merits case and one emergency docket case, and talk a little bit about what they mean for where the court is on executive power in the context of administrative law. So just to kind of give you a little bit of background and context for where I'm coming from, for the last 10 years or so, there's been a bit of a tension and a puzzle for people like me who study administrative law, because on one hand, the Supreme Court has been quite skeptical of executive power in a whole series of cases. The cases that whittled away at Chevron eventually overturned it. Chevron deference is this principle of deferring to administrative agencies, no longer the law after Loper-Bright. The major questions doctrine as well, clearly skeptical of the use of executive power through agency action. And then there was the non-delegation doctrine, which reared its ugly head in Gundy versus the United States after a very long dormancy period. There was a lot of speculation about that coming back. So the court had been quite skeptical of agency power, and agency power is executive power to some degree. On the other hand, it was doing all kinds of things, citing the unitary executive theory, to really drastically change the president's relationship to the executive branch. So in Saylor Law versus CFPB, the Supreme Court very much changed the law on removal of officials in independent agencies, and I'll talk about a case just this past term that pushed that even further. So there's a bit of this tension, limiting agencies, but also empowering presidents. But people saw some kind of tension there. Jody Short and Jed Sugarman have a great piece, if you haven't seen it, called Major Questions About Presidentialism, which really highlights this tension. So I think that this latest term has in some sense resolved that tension in favor of executive power and quite empowered agencies. And I want to explain why. So I'm going to talk about first the FCC versus Consumers Research decision on the non-delegation doctrine, and then Trump versus Wilcox on the removal question in independent agencies. So first, on the FCC versus Consumer Research opinion, this was on the merits docket, and it was the latest challenge under the non-delegation doctrine. The non-delegation doctrine, for those of you who aren't familiar with it, is the principle honored in the breach, some would say, that Congress cannot delegate any of its legislative authority to administrative agencies. Now, it can delegate something. It just has to delegate authority with an intelligible principle to guide the discretion of agencies as they implement the law. So that's been the long-standing legal test that the court has deployed in non-delegation cases. And it almost always works for the government, historically, very rarely used to strike down a congressional delegation of authority to agencies. But as I mentioned a few years back in Gundy versus the United States, there was some rumblings about the non-delegation doctrine, and then this case teed up the issue once again, coming out of the Fifth Circuit, a pretty broad delegation to the Federal Communications Commission. Very surprisingly, the Supreme Court rejected the non-delegation challenge quite broadly, really slapping down the Fifth Circuit, which has been invoking the non-delegation doctrine quite a bit in its docket, and really kind of slapping down that circuit and saying, we're not in the business of policing legislative delegations of authority. Very much affirming the intelligible principle test as the governing standard, rejecting what Justice Gorsuch had suggested in his dissent in Gundy versus United States, a very different formulation of the non-delegation doctrine that would be much more stringent. So essentially getting out of the business of policing, or even potentially policing, delegations of authority. Very interestingly, in this case, the conservatives partially went in the direction of upholding delegations of authorities to agencies. So Justice Kavanaugh, Justice Barrett, and Chief Justice Roberts, who had previously in Gundy actually said, I would be interested in reviving the non-delegation doctrine. He also joined the majority opinion upholding the delegation to the Federal Communications Commission. It was really only Justice Alito, Justice Thomas, and Justice Gorsuch who still continued to sound their concern with the non-delegation doctrine and wanting to revive it. So that's quite a turn. And I think coupled with the next case I want to briefly talk about, since I'm running a little long, it really signals an acceptance of a large amount of authority in the administrative state that a president can then wield as the president sees fit. So now to that second case, which is the kind of second leg of this big pivot that I see happening on the court. Trump versus Wilcox involves a couple of firings of officials at independent agencies, multi-member commissions, very much the type of agency that had been hinted to be totally constitutional in Saylor Law versus CFPB just a few years back. Not going to get into the details of that opinion just now, but the court said that there were some exceptions from the traditional rule that the president has to have plenary authority to fire agency officials. And arguably, these officials fit right into one of those exceptions. However, on the emergency docket, the Supreme Court decided that, in fact, the president does probably have the authority to fire those officials because they're exercising executive power. So maybe creating yet another exception or a different gerrymandered rule, if you will, to determine when the president can fire agency officials. Again, I'm running very long, so I'm just going to stop there and say that when you couple the two of these cases together, the picture that emerges is of agencies that enjoy lots of discretion under their existing delegating statutes that are now under more and more control, potentially complete control, if the chain of the unitary executive theory goes far along and continues to be implemented. The president having plenary authority over agencies exercising those delegated discretions. So I think that is quite a significant development. It's a big turn from prior years in which the court was, at least in rhetoric, deploying a lot of anti-agency rhetoric. It seems to me that the theme of the term, in some sense, if you wanted to dramatize it and put it in movie form, would be how I learned to stop worrying about the administrative state. Wait, what's the Dr. Strangelove thing?
And love the bomb.
And love the bomb. Yeah.
You missed a rather important part.
I did. Yeah.
Thank you so much, Dan. Keith, welcome. The floor is yours.
Thank you. So I am used to being last on alphabetical order panels, but this panel seems like it's really teasing me about the fact that I'm last. I could have so easily have been somewhere else. So close, but not quite. So I'm willing to keep my powder dry a bit on thinking about how the court ultimately resolves some of these issues of executive power in the next term or two. I'm not quite as willing to assume that because the court has done what it's done and the orders it's issued on the emergency docket, that necessarily is going to tell us just how supportive of executive power the court's likely to be when these things come up on merits. Although I agree completely with Steve that what the court has done in effect is facilitate what the Trump administration is doing. And that itself is quite extraordinary. The Trump administration has been extremely aggressive about how it wants to try to exercise executive authority. And it's done so not only by going to courts and offering near frivolous arguments on behalf of its own authority in support of those cases, but also not doing what traditionally administrations have done. So notably, for example, you would expect an administration making these kinds of aggressive moves and exercising executive power would also be issuing a flurry of Office of Legal Counsel opinions justifying and explaining where this power comes from and what the legal sources of authority is the president's exercising. We have none of that out of this administration. The administration is offering very little in the way of legal reasoning to support its actions. I think in part because they're not all confident they actually can come up with plausible legal reasoning. And so instead, what they're doing is exercising power extremely aggressively and then daring other institutions to resist them. And the court, I think, partially for procedural and other reasons, has been somewhat reluctant to allow the district courts to be as aggressive as some of them have been in resisting the Trump administration. And it may be the case that by the time some of these issues wind up reaching the court on the merits doctrine, they will look pretty different than they do now. So part of what the administration is doing is moving very aggressively in areas where they have pretty dubious authority, I think, to act, and have done it in extremely sloppy ways that have made them more legally vulnerable than they might otherwise have been. But that may well get cleaned up over the next 6 months to a year. So, for example, there was just a leak the other day from the General Counsel of Health and Human Services providing legal guidance to that agency, that department, as to how they ought to be making decisions and justifying actions in rescinding or not offering research grants. This particularly includes the National Institutes for Health. So that's the big set of science grants going to universities and medical schools, in particular that the Trump administration has leveraged very aggressively in order to put pressure on universities, and courts have just quite recently said that many of those rescissions are illegal. And part of what HHS is now trying to do is say, okay, going forward, we got to be a little more careful about how we go about doing this. We're going to put some other procedures in place. We're going to take a little more time to justify these than what we've been doing in the first few weeks of the administration. And as a consequence, we anticipate these are going to be more defensible in court if we take those actions. And the problem for example, universities and medical schools facing these kinds of withholding of grants by the federal government is that was always going to be possible. That these initial moves of, for example, rescinding already given grants to Harvard and Columbia, for example, have a somewhat dubious legal basis, but 6 months out, when the question becomes, well, do you get new grants for the next year, the administration has extraordinary flexibility under existing statutes as to what kinds of discretion it wants to exercise. And so if it can get its ducks in a row about those issues, it's going to have a lot more flexibility to make the same kinds of moves substantively that it's making now, but on much firmer legal grounds. And so by the time the Supreme Court winds up hearing this on a merits basis, they're going to be looking at a pretty different case, probably, than what the district courts are currently doing, just in terms of how well the administration is complying with the Administrative Procedures Act, about how it's making agency-level decisions, and in terms of what kinds of statutory authority it's exercising on some of those issues. It's still going to have some constitutional concerns on some of these questions. So, for example, withholding federal funds from universities. I think there are quite reasonable First Amendment claims that universities can make vis-a-vis the federal government about why they're withholding those funds from specific institutions and what kinds of demands they're putting on those institutions. But nonetheless, I think universities are looking down the game tree and realizing while we might be in a good legal position right now, we're going to be in a lousy legal position 2 years from now. And in the long run, that means you've got to negotiate and figure out how to cut a deal with the Trump administration at the end of the day. And I think that's what the Trump administration has really been counting on, that they take this shock and awe strategy. It will survive with some legally dubious claims in the near term, but eventually people will come to the table and they'll be able to get a lot of what they want through negotiated settlements in the longer run. And we're probably going to see that across a whole range of issues. Certainly it's the case, I think, in thinking about withholding federal funds from universities, but I think that's also the case in some other contexts as well. So let me circle back then finally to talk about the birthright citizenship case. I've been doing a lot of research on the substantive issues of birthright citizenship. Unfortunately, the court has punted that issue to next term to actually deal with the substantive question about what the Constitution requires in this context. It's an extraordinary thing for the president to assert through executive authority that he can change the state of the law and policy on this issue. So that by itself is extraordinary. I think the substantive claims about what the 14th Amendment means are, again, border on the frivolous. And so I actually anticipate that the Trump administration is ultimately going to lose on the substantive claim about birthright citizenship when we get there. But what the court focused on in this term was not the substantive underlying claims about birthright citizenship, but rather the question of national injunctions by district courts. And this has been an issue that has arisen already in the birthright citizenship context, has arisen in lots of other contexts. So there were plenty of other vehicles the court could have used to address this, even in the Trump administration. But it's arisen across multiple administrations prior to this. This is the process by which district courts, hearing a particular case in front of them, are issuing injunctions that attempt to stay some action that parties are claiming are unlawful that the administration is engaging in, and purporting to control not only the parties in front of them in that particular case and in their own geographic district that the district court sits in, but also control the administration's actions across the country as a whole. So if you get a friendly judge and you challenge what the administration is doing in a single courtroom, you can get a nationwide injunction that will put the whole thing on pause for a lengthy period of time as you're going through the appellate process. This very much concerned Democratic administrations when Democratic administrations were being hit with this, which they were very aggressively being hit with. It has bothered Republican administrations as well, and so the court had sort of let this issue linger, but has now tried to resolve it by paring back on nationwide injunctions. And there's sort of two kinds of issues at play here. One is sort of simply the legal issue of what kind of authority do district courts actually have under the Constitution, under statutes, to issue these kinds of injunctions. And the court wound up dividing on that, with the conservative majority being quite skeptical of the authority of the district courts here, and the dissenters being more supportive of the underlying legal claims. But there's also, and this played more of a role in the dissenting opinion in that case, a core policy concern here, which is grant for a moment, which came up in oral arguments, it comes up in the dissent, and it's certainly very much a real issue to be thinking about. Imagine for a moment that an administration, whether it's this administration on this particular issue or some other future administration on some other issue, has engaged in egregiously unlawful behavior, has issued some kind of policy decree, some kind of regulatory action that is clearly unconstitutional or clearly violates statutory authority, and yet they want to start implementing it. We're seeing a lot of that with this administration. What's a court to do confronted with that, and how much tolerance should we have for the possibility that administration might not only be willing to issue that aggressively unlawful order, but likewise be willing to say, okay, fine, we lost in this one court with this one party. We're now going to make every individual affected by our policy action go separately to court to get a new judicial order against us in a different context? Or is the administration going to say, okay, we're going to defer to that while this is being litigated out, we'll just put the whole thing on pause voluntarily while this plays itself up the chain? To some degree, the court's majority, from a policy perspective, is still relying a bit on the idea of presidential norms. The presidents are going to recognize if we're losing in the district courts, we shouldn't be very aggressive about trying to enforce this policy. We shouldn't force everyone to have to go to court to get a separate injunction against us. And the dissent, I think, is quite skeptical that at least this president, maybe all presidents, are going to adhere to those norms. And so instead, we're going to find ourselves in situations in which the court believes, and also lower court judges believe, the administration is doing something that's egregiously unlawful. They're continuing to engage in it, and they're just playing out the clock as we're waiting for those issues to work their way through the appellate process. This causes problems for the emergency docket as well, where the court's very much in this pickle of how do you deal with the fact that the litigation takes time, but executive branch can move very quickly under some circumstances, and that's the worry in the nationwide injunction context specifically.
All right, great. Let me begin by allowing each of you to respond to one another, if you wish.
So I guess just, I mean, Keith's last point, I think, raises what has been, I think, lurking in our conversation, but not stated expressly. Formally, what is supposed to differentiate emergency applications from plenary review on the merits docket is not the merits. It's the existence or not of what courts call irreparable harm. And the idea is that emergency relief is supposed to be predicated on the idea that you're likely enough to win on the merits, and you're going to suffer harm if we don't make that the status quo now. What is so, I think, frustrating about the fact that the court is so seldom writing is that it is not at all obvious in many, if not most of these cases, how the hell the irreparable harm argument supports the government, right? And so take the birthright citizenship case, for example. If you believe, as most people, regardless of their political persuasion, do, that the birthright citizenship executive order is unlawful, how could the federal government possibly be irreparably harmed by it never going into effect? Right? If you are worried about federal employees losing their jobs versus whether the government has the authority to fire them, there's a slight difference on the irreparable harm piece of this story. And so what we've seen over and over and over again is the Democratic appointees, most notably, but not only, Justice Ketanji Brown Jackson, saying all that the majority is doing in these cases is voting their preferences on the merits. And what that misses is Keith's exact point, which is that in the 18 months, 2 years, 3 years it takes for these cases to get back to the court on the merits, maybe things have changed. Maybe they've changed politically. And when the time comes, we actually find a Supreme Court that wants to rule against many of President Trump's policies. But the amount of harm that those policies could, and in my view, are inflicting in the interim is not just, in many cases, potentially catastrophic. It's not clear to me it's reparable. And so, what's frustrating to me about the court is not that it is a 6-3 conservative supermajority that has views of executive power with which I disagree. Like, it's the nature of the business we're in, right? What's the line from The Godfather Part 2? It's the business we've chosen, right? It's that the court is basically throwing the notion that what it's supposed to be doing in emergency applications is something different totally out the window, and almost admitting as much in its opinions. And I think that's a big part of why it feels to so many of us like the court is siding with the Trump administration, even without saying, yes, this is legal, because it's not taking these harms, it's not taking this very different reality we're in today nearly as seriously as I think it ought to be taking it.
I'm glad you brought up the irreparable injury point, because that's exactly what I was thinking today as I read the case that was decided today by the Supreme Court. I mean, there's just no argument on irreparable injury that the equities favor the administration over the many people who are going to immediately face losing their job. Anyway, I actually have a question, I guess, for Keith and the panel, inspired by Keith's remarks. And I mean, the way that you described the dynamic as it's taking shape here is, it sounds more palatable, right? In a sense, it's a negotiation, right, between the Supreme Court and the president, right? And negotiations, you start with your strongest bid, and then you meet somewhere in the middle. Maybe the middle's more acceptable, right? On the other hand, do we have any hope that the Supreme Court has the capacity to be an effective player in a negotiation with the executive branch? Justice Kavanaugh's concurrence in the birthright citizenship case, it just goes on and on about the possibilities the Supreme Court will be that ultimate check. But at the end of the day, the Supreme Court and the judiciary as a whole is a very limited institution. Not only can they not hear every case, and it takes time for them to hear cases, but there's also the possibility of executive flouting of orders hanging in the background, right? So it just seems to me institutionally unrealistic to expect the president to give anything in that negotiation. It seems to me that Trump is going to continue to play his strongest hand and call the bluff of the Supreme Court and the judiciary. So what gives us confidence that it'll play out in a more palatable way?
Keith literally wrote the most important book on this subject, in my humble opinion, Political Foundations of Judicial Supremacy. I think it was back in 2007, is that right?
I think that's right, yeah.
Okay, so
well, I mean, I don't have a great deal of confidence about what the court's position is in that kind of negotiation with the administration over time. I think part of what courts have shown themselves to be in the past is pretty slow to catch up with political realities in some of these cases. So part of what this reminds me of a little bit is sort of the massive resistance campaign and how courts struggled to grapple with political actors who were looking for every opportunity to circumvent courts, right? And so the sort of assumptions courts want to work with is everybody's going to be a good faith actor, they're going to cooperate, we're going to follow a set of norms, and then you deal with a set of political actors who aren't going to do that. The court also confronted that with the first Trump administration as well, and it sort of pushed on the court for a while, but they never really resolved it. One kind of response you could imagine, besides the sort of, you could do all these orders differently on the emergency docket and give the lower courts more leeway in what they're trying to do. But you could also imagine the court starts changing how it wants to proceed, right? You could decide these cases quicker. You could decide a lot more cases than it was. So this court, and not just this immediate court, but the court over the last many years, takes an extraordinarily few number of merits cases compared to courts in the past. They could be taking a lot more. They could move these through the system much faster, and they could be more aggressive about how they respond to an administration like this than they have in the past. But I don't think the court is caught up with how the executive branch is thinking about itself.
I guess I wonder what the breaking point is.
Well,
you know, imagine a...
So this is right. I mean, this is why. I mean, I have written a lot. About one particular case, the so-called DVD case, which, you know, for those of us of a certain age, we associate with something other than people. So the DVD case, this third country removals case, Neil alluded to it in his opening remarks. This is a case where, you know, there are messy questions, not about the merits, but about whether the federal courts have jurisdiction to block certain actions by the executive branch when it comes to the removal of migrants to third countries, so countries other than the ones that were designated in the removal proceeding. And what is so striking about this case is there was outright, not the sort of like, well, maybe they didn't, there was outright defiance by the federal government of the district court's injunction. So much so that this is how 8 people ended up in Djibouti because the government removed them in violation of Judge Murphy's order. And what was really shocking about the fact that the Supreme Court granted emergency relief, even in that case, was that the court didn't say a word. And I mean, I've been beating the drum about the court not explaining itself, but here especially, the court did not say a word about the government's defiance. So imagine if the court had said, we are deeply disappointed, you know, the government's behavior in this case was reprehensible, but our job is to apply the law, right? Like, that's a different ruling than just stay granted. And my concern is that what that enables on the government's part is more and more defiance of lower courts, and they just have to dot their I's and cross their T's with the Supreme Court. And, you know, maybe the justices can tell a plausible story to themselves that defying a district judge isn't the same thing as defying the Supreme Court. I gotta say, it's the same commission from Article 3 of the Constitution that's sitting on both of those judges' walls. And I don't know what the constitutional principle is that says it's okay for the president to not comply with a binding order of a district judge, but it's not okay to not comply with the ruling of the Supreme Court. And so I'm worried, Dan, right? I worry, first of all, I think you're exactly right? If a negotiation presupposes 2 sides with equal bargaining power. But second, I worry that like the court has in some respects already let the government cross the Rubicon. And it's going to be hard if and when we get to the case where the court's like, no, we really are pushing back, for the court to, you know, realize how much ground it had already ceded.
All right, so let me push back, right, and interpret what the court is up to, at least part of it, in the most charitable way I know. The rule of law, the Constitution, the court's own authority has political foundations, right? Dan asked the question of why would the president ever obey the Supreme Court when the president doesn't want to? Well, it turns out there's a long history of presidents doing that, and there's a little history of them not doing it, but a lot more history of them doing it. And in part, that's because Supreme Court justices have learned through hard experience to be politically skillful. And if the Supreme Court says to the administration, you come to equity with unclean hands, we're ruling against you just because you defied a lower court order, and this birthright citizenship argument is nonsense, and we're ruling against you just because, you know, and this Alien Enemies Act, I mean, we're subject to an invasion or predatory incursion attributable to the government of Venezuela. Are you kidding me? Right? If the court does all this, it increases dramatically the chances that the administration is going to openly defy an order or decision of the US Supreme Court. And at that point, we are in a full-blown constitutional crisis, and the question becomes, which side is the military going to join? And maybe the court has an interest in avoiding that. And maybe liberals should be more politically skillful in condemning the court all the time for not going as far as some of these district judges.
Okay, there's a lot there, and we have about 1 minute and 45 seconds. Let me just say, so I actually think this is, in fact, the best defense of what the court has been doing. It's one that's been made publicly by my friend Will Bode. I think it is unquestionably true to a point. I did not lightly invoke Neville Chamberlain and appeasement, right? I mean, the best case that can be made about what Neville Chamberlain thought he was doing was he thought that he was actually going to sort of, give the British people time to rally behind the notion of going to war with Germany, that the army would be more prepared, all this stuff. And now it turns out that we know that actually had the war started in 1938, right, Germany would have lost quickly. Or that's the theory, right? So yes, I buy the notion that that's what some of the justices think they're doing. But what's the line? And if the line isn't defying a district court, what is it? If the line isn't putting into effect a blatantly unconstitutional executive order, what is it? And so, yes, I think that's going on. Yes, I think that's part of the story. But I also think that, because the court isn't writing, we don't know what they're waiting for. And if it's high constitutional politics, that's great. But in some respects, a lot of those safety valves have been closed, and a lot of those lines have been breached.
So we have less than 30 seconds, but I just want to say that while pointing Neville Chamberlain as the example, of course, gives it a bad spin. But the other kind of spin is, say, you could point to John Marshall. Because Chief Justice John Marshall did this all the time through his entire tenure precisely because the court was extremely fragile and vulnerable, and he knew that. And so his primary goal was, how do I not pick a fight that I can't escape with the other institutions of government, because the court's going to lose that fight. And to some degree with this administration, I think the court has to confront that seriously.
Just briefly to add to that and maybe close the conversation, hopefully. John Marshall's a good analogy, but that was a very different political environment. Yep. And I think you get to the...
We had something called Congress back then.
We had something called Congress back then. People didn't really even know what the Supreme Court was supposed to be doing. Now it's a highly polarized institution. Its institutional legitimacy is in the tank. People have very negative opinions of the Supreme Court compared to what they did even 10 years ago. I think that different environment means that it's different politics. And to Steve's point earlier about transparency and writing opinions on the emergency docket, doing the work of public relations is part of what the court has to do to build up its legitimacy. And if it thinks it can ignore that, I think it's going to lose this political game.
Interesting question of whether if the court spoke more, Steve would like it more or less. Thank you all, and thank you all for being with us.
Hello, friends, and welcome to our last panel. It is wonderful to convene three of America's most thoughtful Supreme Court commentators to wrap us up. We have Jess Bravin from the Wall Street Journal, Jan Crawford from CBS News, and Fred Smith Jr. from Stanford. Friends, our last panel ended with a vigorous discussion of whether the current court represents the triumph of John Marshall or Neville Chamberlain, and also the competing visions of Justice Jackson and Justice Barrett. And I want to start with that remarkable debate now. In the Trump and Casa case, Justice Jackson, in her separate dissent, accused the conservative majority of creating a zone of lawlessness that represented an existential threat to the rule of law. And Justice Barrett responded, 6 justices in the majority, that Justice Barrett's dissent has no basis in 2 centuries of precedent, not to mention the Constitution. Jess, your so thoughtful in your reporting. Who's right? And is this historically unusual?
Well, it's emphatically the province and duty of the news department not to say who's right, but simply to say what they have to say and leave take readers up to the step of drawing their own conclusions. And I think that it really starts with the presumptions that readers and audiences have about whether this is a moment of tremendous tension and crisis for the country, as Justice Jackson suggested, or whether that's an exaggeration and things are not so different than they are as they normally are. And that's really the majority's take of what's going on. There's nothing, this is not some kind of crazy emergency, says the majority, and yes it is, says Justice Jackson, and some of these other some of the other opinions we've seen, also other liberals in dissent saying the same thing. So what they are doing is, they are reflecting the tensions in the country as a whole, and those are not so much legal arguments as they are, senses of what the national mood is, what the zeitgeist is in the United States, and whether the Trump administration is something anomalous and horrific, or something that is just another evolution of the line of democratic succession.
Thanks so much for that. Jan, a version of the same question, but could they both be right? And is this unusual?
Wait, what was the last part?
Is this unusual historically? Have we seen before justices accusing each other of either existentially threatening the rule of law or crying wolf?
I think the language may be a little more pronounced than some of the things, but it's not unusual for justices to have pretty strong views in their dissents. And what I've been most struck by seeing kind of this clash between Justice Barrett and Justice Jackson is when I think back to the 1991-1992 term, when Justice Clarence Thomas joined the court. And unlike some of the other justices, Justice Alito told me once when he came on the court, he felt like he had made a mistake when he was on the Third Circuit. He immediately started arguing to, re-argue cases and rethink different issues. And so he decided that he was going to spend a year, just that first year, just kind of getting a lay of the land, a feel for the court. When you move into a new neighborhood, the first thing you do is, you don't go and tell all your neighbors they need to repaint their houses and the color of your choice. So that was mainly how most justices do it, not Justice Jackson. She's going to tell you, yeah, you need to repaint your house, and in fact, you need to tear that whole thing down. And so that has been very unusual to see her being so assertive, not only in the dissents this year, but certainly in her questions from the bench, where she is literally talking the most from the bench of any of the justices. That's highly unusual. Why I say it reminds me of Justice Thomas is when we think back to, and it's really nice to be here, and I hope you don't take offense at this, but when I go speak at law schools, I'll say, like, when we think back to 1991, or when we think back to the year 2000 and Bush versus Gore, and, they're like, they're not even born yet. So it makes you realize these years go fast. But when we think back to 1991, when Justice Thomas joined the court, after that brutal confirmation hearing, a narrative very quickly developed that he didn't belong on the court, that he was really Scalia's intellectual understudy, his puppet, and that narrative, which I think persists to some extent today, is patently and demonstrably false. You can go to the papers of Justice Harry Blackmun. On that first year on the bench, if any justice changed their vote that year to join the other, it was Scalia changing his vote to join Justice Thomas. Justice Thomas joined the court and immediately began articulating very bold perspectives on the law, and arguing the court should be rethinking vast areas of their jurisprudence, particularly in the issue of habeas corpus and criminal law. And toward in the back half of the term, he circulate an opinion in a case, a habeas case, that so offended Justice O'Connor that in her dissent, she used his name 18 times. Justice Thomas does not understand. Justice Thomas misstates the law. Justice Thomas mischaracterizes a previous opinion over and over. That is very unusual. Typically, the dissenting justice will say the majority, or my colleague, or It was extremely unusual, and it reflected her response to Justice Thomas's bold views when he first got on the court. And what we see that term is, and why this term is so pivotal, and why I would caution liberals who are cheering on Justice Jackson now, is that that term is when you saw Justice O'Connor begin to move to the left. She reacted so strongly at some of the positions that Justice Thomas was taking. She would dissent in cases, but she did not join a single one of his dissents. She would always write separately. Because when a new justice joins the court, it's like the chess pieces get rearranged, right? And so sometimes it can cause people to rethink their alliances, re-examine different rulings. That term, when Justice Thomas joined, didn't really just rearrange the chess pieces, it like just turned the whole chessboard upside down. So you saw Justice O'Connor move more to the left. You saw Justice Souter, I think Scalia helped a little bit here, pushed more to the left, Justice Kennedy. And that was the term when the court refused to overturn Roe versus Wade, refused to allow school prayer at graduations over and over. A court of 7 justices nominated by Republican presidents in case after case was a huge disappointment to conservatives. So when we see this kind of back and forth now in the writings and on the bench between the justices, it does give some concern that perhaps, Justice Barrett has been disappointing sometimes to conservatives. I'm not on the big cases. I'm sorry, Sarah, I apologize I know the first panel, Sarah, gets frustrated with some of the big cases, but, some of the big cases like overturning Roe versus Wade. I mean, she was the vote with conservatives. But Justice Kagan is very strategic, and in some ways like the Chief Justice. And I think had really thought, that Justice Barrett and perhaps Justice Kavanaugh, maybe the Chief, those in the middle, you can have a conversation with them, which what does that do? Open things up for compromise potentially, or at least to consider compromise, so that there is possibility of finding perhaps some common ground. And now when we see that kind of language in that kind of case, the concern would be that you're really doing yourself no favors if you're hoping to find some kind of compromise or consensus or common ground on anything. Because remember, there are only 3 liberals on the Supreme Court. You've got to be able to try to get 2 of those conservatives if you want to have a majority opinion. So that was kind of what I took away. I think some of the language we've seen this term, and we can talk about this later, does a disservice, but it's not unprecedented. And Scalia sure had some doozies too in his day.
That's such an important point about how the polarizing rhetoric of justices can drive each other apart. Justice O'Connor's response to Justice Scalia was, "Sticks and stones can break my bones," and then she said that probably isn't true, and she did indeed move to the center, as you said. And Justice Kagan is having a different strategy than Justice Jackson. Fred Smith, same question, a version of who's right, not in the sense of who you think is correct, but these are completely different views of what the court is doing. Can they both be right? And then history. I'm thinking about the great moments of court polarization. After the court overturned the Gold cases after the Civil War, within the space of only a year, the dissenters accused the majority of acting pure politics. Justice Jackson sniped at Justice Black during the Nuremberg trials and accused him of being a politician. Have we ever seen anything like this in history before?
I'll start with the substantive question, right? Who's right? And specifically the charge from the dissent that the nationwide injunction opinion has created a zone of lawlessness for the president. I think it's too early to entirely say who is right, in part because there are still 3 potential possibilities to hold the executive accountable. One is the class action, right? So we don't know just how strictly the Supreme Court is going to kind of rein in that category, but it could be that we're in a situation where what used to be nationwide injunctions, that a lot of them just get funneled into a different mechanism, in which case we're not in a setting in which there's a zone of lawlessness for the president. The second category is situations in which a state is a litigant And because of the importance of uniformity, they can make the case that only a nationwide injunction will solve their specific injury, which the court also left open in CASA. And then the third possibility is that they did seem to reserve for themselves the ability to say what the law is in a way that would bind the president. Now, that third one is the trickiest, right? Because it depends on a lot, right? So the example I give is a president issues an executive order that says, no one can speak ill of me. And this is just a complete hypothetical. I have no president in mind.
We're going to get a new executive order.
Okay. I actually picked this example in part because it's not necessarily like left or right. So it's a First Amendment issue. Johnny goes to court and says, I want to be able to say the following thing against the president. And a federal district court can issue an injunction for Johnny, but not for anybody else, right? And what matters at that moment is, does the executive appeal? Because if the executive doesn't appeal, it never gets to the Supreme Court. And that third mechanism, the Supreme Court speaking, doesn't really exist, right? It would require me to sue, and you to sue, and you to sue, and anyone in this room who wants to ever say anything bad about a president, it would require them to sue in order to get relief. It also depends on the possibility of whether or not, if a lot of district courts are saying something is unconstitutional, will the executive just press the pause button or not, right? And at oral argument, at least, the Solicitor General strongly suggested that it's not a policy, it's not a uniform policy of the executive to follow even what a circuit court says within a circuit, right? And so are we in a zone of lawlessness? A lot depends on those three mechanisms of accountability and how they wind up. On the question of, is this rhetoric historically unprecedented, I would say no. And I would say that even in this century, it, in my mind, isn't at all unprecedented. I think about the Obergefell dissent by Justice Scalia, where he said that he would rather hide his head in a bag than join an opinion that the majority said. He said that the majority opinion was like aphorisms from a fortune cookie. He said that that everyone on the court was essentially from the Northeast, that none of the people in the majority were from the West. And then he said, because Justice Kennedy was from California, California doesn't count. In my mind, just in terms of, at least from a collegiality perspective, and debates between the justices, at least, to me, this doesn't really register.
Neville Chamberlain or John Marshall, and let's talk about the question of presidential defiance of the Supreme Court. Our previous panelists suggested that if the president disobeyed an unambiguous order of the US Supreme Court, that would be a constitutional crisis. We've never seen it before in American history. Andrew Jackson is supposed to have said, John Marshall's made his decision, now let him enforce it, but even if he didn't utter the words, the court never ordered him to do anything, and he never had to defy Marshall. Lincoln briefly defined Chief Justice Taney on suspending the writ of habeas corpus during the Civil War, but Taney was sitting as a district judge and it wasn't an order of the full court. So we haven't seen it before. And the big question, Jess, is the court afraid that President Trump will defy it? Is Chief Justice Roberts trying to avoid a direct confrontation? Steve Vladeck, quoted Marshall, who said, "I'm not fond of butting my head against a wall in sport." So he tried to avoid those direct conflicts with President Jefferson. And are we going to see the president defying the court or not?
Well, Nazi analogies are always tough, but there's another.
No reason to.
There's also Marshall Patent. The question is, a question like that assumes that the court knows that Trump is wrong and disagrees with him, and is for strategic reasons choosing not to say so. And I think there is another possibility, which some people perhaps overlook, which is that they think Trump is right, and they don't believe that like all right-thinking people, they have to stop him, and they're just waiting until he's looking the other way to do it. I think that you have to look at this court. The majority of the court, the members, their legal careers were built viewing much of the jurisprudence that they had inherited as mistaken and misguided, thinking their job was to correct that, believing strongly in executive power, and not looking at Trump as this malignant force that they have to find some way to resist. I don't know that they are the resistance. I think that we should take much of what the court does as reflecting what they think. And when they say, as they did today in the emergency order on the reduction in force memorandum, that the government is likely to prevail, is because they get to decide who prevails, and they think that he is going to prevail. So we know, yes, there have been a couple of orders involving habeas corpus and deportations where the court did stop the president from moving forward. There was the comment from the Chief Justice earlier in the year about impeachment maybe being a little bit out of bounds when you disagree with a court decision. But I think that we shouldn't assume that they know better than the actual orders that they are issuing.
Jan just suggests that the court is unlikely to issue orders the president defies because it may not check him on the big questions. What about the lower courts? Is the administration complying in good faith with the orders of lower courts, including Judge Boasberg? And how is the U.S. Supreme Court responding?
I think that I actually have been quite impressed with some of the briefing in these cases, the filings that the government has made. It's actually been pretty good, considering that it's just a deluge. And I'm not really sure how some of these district court and appeals court judges are even keeping up with some of this. And that is obviously part of the strategy. I think the concern is that they are going to defy the lower courts and certainly the Supreme Court, but they haven't yet. I mean, they've come close. And I know our previous panel would disagree with this, but I do think the court is worried about that, which explains some of one of the rulings that you mentioned and how they handled that and said that had to be sent back to Texas, or the habeas matter. But they haven't yet. I think one of the things that's notable is that in the case involving the third-party removals, you could argue that it was the federal district court judge that was defying the Supreme Court when the court said that they were lifting this injunction, and the judge said, well, only part of it, the other part's still going to be in place, which prompted a pretty extraordinary clarifying order from the Supreme Court that they really meant what they said. I think my biggest frustration with some of these emergency orders is that they're coming to the court in a preliminary posture. For example, the case today, the reduction in force case. Obviously, we all know, or I'm sure most of you, you obviously are very engaged and follow the news closely. And Jeff, you do such a terrific job here. We are so lucky to have Jeff helming the Constitution Center. And y'all are so lucky to be in Philadelphia to get to come to these things. But the order today and the reduction in force, obviously President Trump issued an executive order and a memo directing the agencies to just basically develop plans for cutting massive numbers of federal employees in their workforces consistent with the law. A federal judge said that order and memorandum was unlawful. The Supreme Court today in an 8-1 order, which means that Justice Kagan and Justice Sotomayor agree with it, said, well, no, the executive order and the memo are not lawful, and the government was likely to prevail on that in the unsigned order, the court said. So the agencies can go about formulating these plans, but when you get those plans, those could all be challenged. So the order today was extremely preliminary. Really didn't decide anything other than, okay, the lower federal court went way too far in blocking the order as unlawful. And so, sure, the agencies can go about, developing restructuring plans under the terms of this executive order, but all of those plans can be challenged in court. So bring them back when you want to challenge them, and you know that's what's going to happen. So this was really, kind of the initial volley in any of these cases. They're very premature. So I agree that it's very difficult to draw any conclusions on what the court's going to do when they actually get to the merits of some of these cases, especially the case that everyone calls birthright citizenship, which was never about birthright citizenship. That case was about whether or not federal district court judges could issue these sweeping nationwide injunctions that would bind every person across the country in any issue, even if they weren't parties before the court. And as we heard, the presidents in both parties have long opposed these. President Biden, Solicitor General, urged the Supreme Court to please rein in some of these nationwide injunctions, and that's all the court did in that case. The court said that, limited, and I agreed with you, Fred, that it's probably not going to have that much of an impact at all. Limited the kind of circumstances when judges could enter these nationwide injunctions, but that doesn't mean that birthright citizenship will ever see the light of day. They're just going to have to challenge it in the proper way. So one way of looking at this court is not they're rubber stamping things Trump's doing, but they're actually demanding that process and procedures be followed.
Fred Smith, you've written a lot about judicial legitimacy. The moments when the court's been most concerned about its legitimacy include Little Rock, where all 9 justices signed Cooper v. Aaron in hand because they're so afraid of being defied. Is this court afraid of being defied? We've seen it act together in saying that President Trump had to facilitate the return of Mr. Garcia, and will its concern about legitimacy affect its confrontations with the president moving forward?
Yeah. So, well, first I want to just clarify. I didn't say that the opinion isn't going to have a big effect.
I'm sorry.
No, it's okay. Yeah, what I said was that we don't know how far. We don't yet know just how what the effect will be. You mentioned the APA cases, so since you did, I do want to point this out because I think this is something that I am concerned about. I am concerned that the Supreme Court's nationwide injunction opinion may have made one of the biggest problems with nationwide injunctions worse. So one of the biggest problems with nationwide injunctions is that people go to courts in a place where they're quite certain, or they feel quite certain that they're going to win. And then you have these situations where a judge of one party is issuing a ruling against the president of the other party, and then you just see that over and over again, and it affects the perception of the Supreme Court in ways that are troubling. It's not clear to me that this opinion is going to solve that problem, and I think it might make it worse because of the APA. So this is something that we're not going to necessarily immediately see, but I'll give the example of the Mifepristone case, where a judge issued what it looks like. There were a lot of critiques, and people referenced it as a nationwide injunction because it was a nationwide order vacating a regulation by the FDA. Justice Kavanaugh's concurrence makes clear that setting aside regulations does not fall within the sweep of CASA, right? So when it comes to environmental regulations, et cetera, and when in a future administration, when there are lower court judges who are doing that, and the American public was told lower court judges can't do that anymore, I think that the problem will even be worse. And only Congress is institutionally situated to solve the national injunction problem by mechanisms like 3-judge panels or specialized courts, things that the Supreme Court just isn't institutionally capable of doing. So that's my fuller, I wasn't on the nationwide injunction panel, that's my fuller perspective on that. In terms of, is the Supreme Court concerned about about future confrontations with the presidency? It's really kind of hard to say, but historically that is something that that the court has been concerned about. The Marbury versus Madison example is, of course, the clearest. And even in Federalist 78, right, Alexander Hamilton reminds that the courts, they don't have the power of the purse, they don't have the power of the sword, right? And so they really have always understood that a reservoir of some degree of acceptance from the American public, at least enough that the American public believes that it's important to follow their orders, that has always been an important part of the court's institutional capital. And what's hard in these moments is that there's kind of these short-term ways of thinking about this and longer-term ways of thinking about this, and it's impossible sometimes to predict how things will be viewed in the longer term, right? So sometimes the way we think about this is, well, if the court just kind of steps back and they don't have the confrontation and they save their capital, then they're kind of protecting themselves, right? But historically, there's moments in which the court looks worse because it didn't act, right? And there's instances in which the court acting ended up giving it more capital. No opinion gave the Supreme Court more capital than Brown, right? And that was not a moment of the Supreme Court stepping back. But in terms of kind of the longer term perception, in terms of where the American public ultimately went on those issues, it ended up benefiting them, right? And so it's a difficult kind of prediction to sort of make in terms of whether or not standing back versus acting is the move that's going to best preserve the court's capital. But I would say that in the close cases, it's better to act. And I'm going to say my kind of bomb-throwing sort of statement. I think that if a court has jurisdiction and has the ability to stop an ongoing constitutional violation and refuses to do so, it is ethically the equivalent of when a police officer is watching a fellow officer commit a violation and doesn't intervene to stop it. They become complicit in the violation. And so to the extent, if a court really believes that it has the jurisdiction, it has the ability to stop an ongoing constitutional violation, and it does not do so, I find that concerning.
A powerful point that the court sometimes establishes its legitimacy by acting, and also that it's hard to tell, and that the court thought it was being heroic in Dred Scott, but proved to be wrong. But in Brown, it was the source of its capital. When you think of the areas where the court is most likely to confront the president, Jess, what will it be? After all, in the first Trump administration, President Trump lost a fair amount before the court, so surely he's going to suffer some important defeats. What are the big areas where the court is likely to check him?
Well, one thing, the question of whether President Trump would defy the Supreme Court was a question that also occurred in his first term, and he came close in at least one case, and that was the citizenship question on the census form. And after the Supreme Court was quite clear, the Chief Justice writing that opinion saying that the disingenuous reasons given for placing that question on the form invalidated the process under the Administrative Procedure Act. The president, through his preferred medium, then known as Twitter, gave various contradictory instructions to DOJ attorneys who were often left sort of unsure what to say when they were in courts in follow-up hearings after that decision. And I certainly know from our reporting at the time, and you probably too, that there was discussion at the Department of Justice and the White House about whether there was some way to decide that they didn't have to comply with what that opinion seemed to say. So it's been in the background throughout the Trump approach to Article 2. In terms of what cases are going to really raise, give the court less breathing room than something about whether agencies can prepare layoff plans. One thing I would say maybe is the punitive orders against law firms. No, it's not there yet. It's not there. Well, the government is lost.
Yeah,
and
they
everything.
haven't even.
They've not filed any emergency applications on that yet, but they just did appeal one of them to the DC Circuit. I mean, we thought, it's possible they'll just kind of drop it and they'll just, until they run out of law firms to issue executive orders against. But no, they are appealing one, and they may appeal the others. And if they take that one to the Supreme Court, I think it will be a very interesting test for them, because it's a novel use of an executive order. And there are, we haven't had a lot of bill of attainder type questions, come before the Supreme Court recently. I think that one is one where they may push back. And similarly, when there seem to be, viewpoint discrimination cases, targeting of universities because of their, internal organization or their curricular choices, I think that when the court's sort of very aggressive free speech jurisprudence runs into executive orders, unilateral actions by the president intended to punish speech he doesn't like or to repress political opposition, I think those are the ones will be the most interesting. Ones involving the organization of the executive branch, I think the court is more likely to give the president much more leeway.
Well, they've signaled that in, recent cases, including one when Biden was in the White House, that they're going to give him, the president should have more leeway in replacing some of those, like NLRB and some of those boards.
I wanted, though, just to add a little gloss on what Fred said about Brown. While Brown had been argued once under Chief Justice Vinson, they couldn't reach a decision. Chief Justice Warren comes in and says, we're going to do this. And that was true. But then a few years later, when they had the interracial marriage cases, we know from looking at the justices' papers that they chose not to go forward in striking down those miscegenation laws because they were afraid it was too much to add that on top of school desegregation. I mean, they eventually did. They got around to it in Loving versus Virginia. But that question arose years before, and they already knew that was unconstitutional, and they decided to wait because of this very issue, I think, if I'm not mistaken, Jeff.
A crucial observation, absolutely. Justice Frankfurter thought it would be bad for the country, and the South wasn't ready for it, and as a result, he delayed for more than a decade after Brown until the court finally struck down anti-miscegenation laws. Fred Smith, what is the role of pragmatism on this court? In Trump v. U.S., Chief Justice Roberts' majority opinion seemed to be based not in text or original understanding, but on a pragmatic concern that future presidents not prosecute their predecessors. And we've seen the liberals accusing the conservatives of being guided by pragmatism. Also in the Section 3 14th Amendment cases, are these conservatives in fact pragmatists?
I think in the two cases that you just mentioned, it's hard to fully understand them on any other basis. And attempting to sort of describe them in any other basis, actually, I found distorts the Constitution. It's less clarifying in terms of what the Constitution means than not, that it's actually better just to acknowledge that in the Section 3 case, that a big part of what was going on was the practical concern that if states were in a position of disqualifying presidents, that it could lead to untold potential problems for the democracy. And they reached the conclusion that as a result, they needed to intervene. And then they found enough things that looked enough like law to get there. If you try to actually parse it out and describe it as, well, this is what Section 5 of the 14th Amendment means in terms of congressional power, et cetera, it actually makes it harder to really understand what Section 5 of the 14th Amendment is all about than to kind of understand the practical reality. Now, in the criminal prosecution case, that one is in some ways trickier because it's not altogether out of bounds compared to where the court reached with respect to civil suits against the president in Nixon versus Fitzgerald, right? So it can be explained actually on the legal basis of precedent. I think what gives people pause about that one is that there was no originalism. And so people have kind of come to accept that when it comes to novel constitutional questions, that's where this court is going to look. And instead, it looked to a precedent from 40 years ago and extended it. And so, in terms of the question of why did they look to precedent versus why did they look to originalism, that might be able to be explained on practical grounds. But I think the opinion itself can be explained by virtue of kind of extending some principles that were already present in Nixon versus Fitzgerald. But on Section 3 specifically, I think that one's hard to understand on any other basis than they thought that this was the best way to protect the Republic.
Jess, Jan, and you and I have been covering the court for a very long time, and things sure look different today than they did when I started at the beginning of the 90s and when both of you started in journalism. How has the coverage of the court affected the court itself, if it has? And are the justices responsive to the explosion of new media outlets, from blogs to social media, partisan and nonpartisan alike? How are they responding? Jess?
Well, actually, when we heard the other panel, and there was when Jan was talking about Sandra Day O'Connor, I thought of your famous cover story about it's just Justice O'Connor's world, and we're just living in it. And I was thinking, boy, it's a really different world now. I don't think we're living in her world anymore. Yeah. We're living in a different one today. Well, I think the Supreme Court members have a bifurcated view of these things. I think they simultaneously don't care at all about the coverage of the court, and they also care intensely about it at the same time. They don't believe they're influenced by it, but from offhand comments, I'd say they read a lot. They're very familiar with podcasts and blogs, and they're interested in what people are saying about them. Whether that affects what they do, we don't know, but there was a lot of criticism from the right wing of Justice Barrett earlier in this term when she cast a number of votes that went against the Trump administration's interest. And I know that we've seen some of the people in the exosphere, or whatever it's called, claiming some responsibility for helping her get back on the right path in more recent decisions. Now, I doubt that she believes that that's what's going on, but there is this question of how much does the reflected view of themselves affect what the justices do. The court in some ways has made itself more transparent in that they have now live transmission of arguments, and the briefs and opinions are posted immediately, and there is more opportunity for people to see the product of the court, but there is certainly no more insight into how the court is producing that material, especially on the emergency docket, except for the occasional, too occasional in my view, leak of drafts or internal discussions of what's going on. I wish we could say more clearly whether, the court keeps its distance from most journalists, as you know, more than some former members did, I think. And that is because they are more distrustful of the media. I think that the leak of the Dobbs opinion caused things to get tighter around the Supreme Court in a number of ways. It also caused a lot of news organizations to treat the court more like a political institution and cover it more like a political institution, and look at the personal relationships of the justices, look at potential conflicts of interest, look at who they're talking to, being influenced by, more like they cover political officials. And I don't think the court likes that, and that increases their own cynicism about the way they're being covered. But ultimately, though, all of them pretty much live in a bubble where they're surrounded by people who tell them how brilliant they are and how correct their views are, and seek to help them, attain the results they are after. They don't, I think, apart from their colleagues who certainly do criticize them. They do have different opinions. But the world that they inhabit in the Supreme Court building and the places they choose to go generally is very favorable to each of the justices. I mean, they select where they go, and that tends to be where they go. If you ever look at an interview when a justice gives, whether it's about a book that has come out or about, or they're visiting a judicial conference or a law school, usually the interviewer is someone who is very sympathetic and doesn't ask the kinds of questions that Jan would ask if she had the opportunity to do it. And therefore, I don't know that the justices take very, very seriously a lot of the criticism that appears in the press.
Thanks for that. Final thoughts from Jan and Fred. Jan, how has the court responded to the transformation of coverage so that the court is now covered as if it's a political institution? And has that coverage of the court as a political institution increased understanding of the court or not?
No. I think, obviously, there's been tremendous change. I started covering the court in 1994. And like Jess said, I mean, we wouldn't get argument transcripts for 10 to 15 days. Now you get them within the hour. And so when we would go in the press room after an argument, because we all had to attend because there were no live audio, you had to be there to know what was happening. We would literally, and we were competitors, but we wanted to get it right. So we would compare notes, like, wait, did the Chief Justice say that, or who said that? So that we could really have this understanding of what the court was doing so we could better explain it to people. I was with the Chicago Tribune then, but who people were reading back home who couldn't be in the court listening to those arguments. Obviously now that's all changed. We have live audio. That only started in 2000 with Bush versus Gore, and only for very few cases. And I will tell you this, Bush versus Gore, that was recorded on cassette tapes. And so they ran that out to the satellite truck that was doing the feed after the argument concluded, and they started the playback. So now we have live, instantaneous audio transmission. So it's been, and filings, those are all online, like Jess said. You used to have to go into the press room and request the briefs. They were all in paper. I mean, I know I sound like some old, we didn't go to horse and buggy then, but whatever. It was pretty close. I don't think we had cell phones then either, but at any rate, so all this technology has meant, it's tremendous. I mean, it's opened the court up in ways that people can now listen to the court, they can have a greater understanding of the court, they can get more engaged in what the court is doing. It's also led to new mediums, different people who cover the court, and I don't think, and that's where I think we've seen the biggest change, setting aside the composition of the court, the tools and how people do it and technology, the biggest change is how the court's covered, and I do not believe that it is necessarily for the better. It is covered as a political institution because most of the people disagree with the outcome. They decided, it started when, when Senator McConnell refused to fill Scalia's seat and kept that open. There was tremendous rage there, but we really saw the turning point after the leak of the Dobbs decision, which overturned Roe versus Wade. And, we really started seeing this drumbeat of that the court's a political institution, that it's corrupt. I mean, if you believe everything you read, you're going to think the court is corrupt, lawless, beholden to Trump, driven by politics. All of that is patently false. It's not true. These are justices who have very different views on the law. They're engaged in this titanic struggle over their ideologies. They're not corrupt. They're not in the tank for Trump. I mean, I'll leave it at that. But they're up there. They're 9 really engaged, smart people trying to figure out what the right answers are. These are hard cases. They typically take cases that have divided the really smart people on the lower courts. And so they have to figure out what's the answer. And that's always what I look at when the decision comes down. Not like, well, they better do this. Like, how are they going to figure this one out? What are they going to do? And that's our job as journalists. That is what our mission should be, is to explain to people who are standing in their shoes that can't be there, can't listen, what is the court doing and how it affects your life. And a lot of the stuff that we've seen recently from the court, some of this breathless tone about scandals, which aren't even scandals, people Venmoing money so they can go buy hot dogs for law clerk parties. So, Justice Thomas's role in the Horatio Alger Society. The New York Times literally sent a reporter and a photographer to Germany to interview a princess who had hosted Justice Alito for a concert. which he reported, by the way, on his financial disclosures. But there's fed this narrative that this court is corrupt. And, you know, my point is, where's the other side? You know, why are we just focusing on one side? Because, you know, we've had Justice Ginsburg and Breyer. I mean, they've flown all over the world courtesy of billionaires. So, you know, let's be fair. But when you put this narrative out there that, you know, you've got your thumb on the scale, that doesn't serve anyone. That, in fact, hurts the court and its view and how people view it as an institution. It undermines the credibility of the court, and that is dangerous, I think, for democracy. I mean, we have a responsibility to cover the court fairly and objectively. I think we try to do that, but not everybody does. And so I guess I would just say, be skeptical of some of the things you're seeing and some of the particularly things on social media, edgy law professors who are trying to build their brand, not the one here tonight. But I would be very careful of some of the narratives out there, because some of it is just not true.
Thank you so much for that. Fred Smith, last word in this great discussion is to you. As Jan mentions, on the one hand, we live in a highly polarized media and political environment. On the other, it's the most marvelous time in history to study the law, because all of the primary sources are online. And how lucky we are to live in a world where we can hear the oral arguments and read the briefs and read the majority opinions and the dissents and hear thoughtful discussions like this one and make up our own minds. That's, of course, the mission of the National Constitution Center and our new annual Supreme Court review with the Texas A&M Structural Center on the Constitution. Fred Smith, when you teach your students about the court, how do you encourage them to learn about it, and what should our audience here do to educate themselves about the Constitution and the Supreme Court?
Oh, wow. Okay. I thought I was going to answer
Over to
that
you.
question.
You can also, you can answer Jan.
Questions tonight in advance. I hope y'all will appreciate. We're like, whoa, where's that coming from? I feel like some of the panels before, they had a sense of what was going to be asked. We didn't.
That's why ours was better.
Well, in terms of how I teach my students, my view is that my job is just to teach the law and to help them understand it the best that I can. And I find that, I mean, I've taught for 15 years, and I found that students' relationship to the court isn't really linear. Like, it doesn't just go like this and it doesn't just go like that. It actually, at different moments, students have different kind of reactions. And I think I do have a job of making sure that cynicism doesn't cloud their ability to understand the law. And what that looks like in different moments kind of shifts, because the importance is understanding. That's what I see my job as. I do want to answer the question of just kind of what the press coverage has meant for the court's own actions. And then I promise I'll end with something optimistic in saying so. I think it has affected some of their institutional practices, right? And we've heard about some of them. I think the relationship to the emergency docket, yes, we don't have nearly enough opinions, but we have more than we used to. We don't have enough oral argument, but we have more than we used to. There used to be none. And I think it's hard to understand that institutional change without appreciating the critiques that the court was facing, and it listened. Some of the critiques around disclosures resulted in the Supreme Court adopting. It's an ethics policy. Again, many people think it doesn't go far enough, but it's more than they had before, right? And so that's an example, too, of there being dialogue between the Fourth Estate and the Supreme Court. So that's that's the most optimistic statement that I can end on.
Beautifully done. For ending us on a note of optimism, and to all three of our panelists for increasing awareness and understanding of the Constitution, please join me in thanking them. Thanks to all.